Good morning, everyone. We'll call this meeting to order at 9:14 in the morning. Jonathan, was this meeting noticed in accordance with the Open Meetings Act?
Yes, it was.
All right, thank you, sir. Good morning, everybody. Again, I think this is our last one of the year, if we are at all lucky. This obviously new territory like the previous in terms of the work that staff has done and that we're doing as we review this. Just a few housekeeping items per usual. Ask that those of you in attendance be respectful of others who are here. Allow them to speak. No shouting over each other, yelling from the audience. I think the folks who have been at these meetings over the last couple of weeks have done a nice job with that, with a few issues here and there, but emotions sometimes run high, but we appreciate that moving forward. From a kind of purpose, we're here to review and make determination on any of the challenges that arose during the recount process. There are a little over 100, I think it's 119 or so, and staff has put forward recommendations on how to address those moving forward. Ask for your patience as we shuffle our paper and figure out what we're doing or how best to move forward. And then once those determinations are made, we'll be looking to certify the results of those partial recounts. And public comment will take place at the end. It was noticed in terms of how public comment will work, but just a reminder, if you are not a challenger or an attorney speaking on behalf of the challenger, your public comment period will be at the end. You'll have 1 minute. We'll have one remote speaker for public comment. If you are a challenger or an attorney to speak on behalf of the challenger or to rebut, you will speak on the actual agenda item. You will have 3 minutes, and I think that's it in terms of just kind of how we expect things to roll. Hopefully we'll move through this relatively quickly. And with that, I will turn it over to Director Brader for, well, Director Brader, would it be best if we do the minutes and then maybe turn it over to you?
Yeah, I'd recommend that.
Okay.
Mr. Chair, I'll make a motion to approve the minutes of the meeting held on December 5th, 2022.
I will second the motion.
We have a motion and a second on approving the minutes. Any discussion? Seeing none, all those in favor signify by saying aye. Aye. Any opposed? Motion carries 4-0. On to agenda item number 2. And now I will turn it over to Director Brader for a explanation and layout of how we got here, what we're looking to do, and what these papers in front of us pertain to. Director Brader?
Thank you, Chair Daunt. So we're going to talk about the recount for each of the proposals and the challenges that were made for the proposals separately. But for the sake of efficiency, I'll describe the general process and results for both recounts now, and then some of the challenges that are before the board. So as the board will recall, this recount was requested by Jerome J. Allen for ballot proposals 2022-2 and 2022-3. It's a partial recount across the state, and it was conducted following the procedures adopted by the board at its last meeting. Each recount had a Bureau of Elections staff member as the Board of State Canvassers representative at the recount. And for each county recounted, the County Board of Canvassers held a public meeting and noticed the meeting. And boards and county clerks arranged to have teams of recount assistants do the hand counting, recounting of ballots. We had some counties use shared locations in one of the counties subject to recount, particularly in the case where only a few precincts or even 1 or 2 precincts from each county had been requested. So for the 43 counties, we had a total of 19 different locations within the counties being recounted. And these recounts took place on multiple days between December 7th and December 16th. For Proposal 2, 93 precincts in 4 counties were requested for the recounts. 87 out of the 93 were recountable. Prior to the recount in those precincts, there were 37,527 yes votes and 22,234 no votes in those precincts. After the recount, we had a gain of 14 yes votes and 20 no votes total. So collectively, this changed the margin by a net of 6 no votes. And statewide, the proposal passed by 861,145 votes. So this obviously did not change that margin. For Proposal 3, 999 precincts in 43 counties were requested. 943 of the 999 were recountable. Prior to the recount, there were 418,657 yes votes and 207,539 no votes in those precincts. And after the hand count, we had a gain of 116 yes votes and 7 no votes. So we had a net change of 111 yes votes. Statewide, this proposal passed by 583,476 votes. So again, this did not affect the margin or did not affect the outcome. So for the 2 recounts, in total, about 94% of the precincts were recountable. The ones that could not be recounted were either because the ballot container was not properly sealed and documented, or because the precinct was out of balance and could not be recounted after we opened the container. You may recall at the last meeting I mentioned that people will often say that out-of-balance precincts cannot be recounted, but often that is actually not the case. Even if the number of ballots tabulated doesn't exactly match the number of names in the poll book at the end of the canvass and can't be explained, we often can still recount that precinct if we determine when we open the container that the number of ballots in the container matches the number of ballots tabulated on the tabulator tape. And so in many cases, out-of-balance precincts actually could still be recounted here. At the last meeting, there was some discussion about Genesee County and some claims that it would be impossible to do recounts there. But in fact, we were able to recount 19 out of the 20 precincts in Genesee County, 95%, which is about the same as statewide. The other reason some precincts could not be recounted is there was a problem with the way the ballot container was sealed or documented. So there were cases where jurisdictions were using an older ballot container or a container that's not currently on the approved list. So those jurisdictions will need to buy new containers. In other cases, the containers hadn't been properly sealed or the seal numbers hadn't properly been documented in the paperwork or signed off on. So when we cannot verify the seal number based on that, we can't recount. I think there was also a situation where the containers actually had been properly sealed and documented, but the clerks mistakenly took them out of the container to bring them to the recount. And so unfortunately, they broke the seals before they got to the recount. So with ballot containers, everything needs to be done properly. There's a lot of steps in the process. If any of them go wrong in terms of approving the container used, the container being in a state of disrepair that could compromise it, or any errors in the documentation that prevents us from doing a recount. So we sometimes see this as well when we do audits, which we will likely see to some extent when we do those audits next month. Ordinarily, we would have already started those, but we're doing them after the recount. And so when that happens, that's obviously a training point for those jurisdictions that they need to correct their container procedures. As far as the change in the numbers of the ballots, votes cast for each proposal, it's pretty much what we expected. Usually when you do a hand recount, you will gain a small percentage of votes for each side, because most often because a tabulator will reject a ballot for something like an overvote, voting too many selections on the race, but when human beings look at it, they can determine that the voter actually cast their ballot, in a valid way, but the machine looked at it and thought it was an overvote. So things like stray marks, machines will count those as overvotes, but when humans look at them, they see that it's how the voter actually marked the ballot was to make a choice for one of the candidates or one of the proposals in this case. There are also maybe some cases where a ballot wasn't properly duplicated and that's corrected. And then the other factor is that when human beings hand count hundreds of thousands of ballots, sometimes humans just count wrong. So you sometimes make a small error in counting as a human being. Machines are very accurate. That's one of the reasons we use machines, not people, to count our ballots in the first place. But for a volume of this many ballots, it's not surprising to see a very small percentage difference in the hand count. But otherwise, it does confirm that the tabulators in these precincts were programmed correctly and counted the ballots accurately. It's not to say that nobody made mistakes. We certainly we have some mistakes in every election. We see that in our audits as well. But by and large, the precincts were recountable, and we were again able to demonstrate that the ballots were tabulated properly. As far as the conduct of the recount went, I think the Bureau of Election staff and the county canvassers and the county clerks, as well as all the recount assistants involved, did a tremendous job. This was the largest recount we have done in quite some time. There was a recount that was initiated for the 2016 presidential election, but that was halted by a court before it was actually completed. In this case, we completed the recount in 43 different counties. This took a huge amount of time organizing, traveling, supervising, and conducting 43 county recounts in 19 locations over 2 weeks, and I really appreciate the county's diligent work in organizing all of this, as we're in the lead up to the holiday season, and I especially appreciate Bureau of Election staff going to every corner of the state, all sides of each peninsula to conduct these recounts, and just would like to give my heartfelt gratitude to Bureau staff who did an excellent job. Finally, for the most part, everybody in the recount did conduct themselves in an orderly and respectful way, but we did have some incidents of challengers behaving in an inappropriate or adversarial manner. We did have instances where, rather than follow the challenge procedure, we had folks who were raising their voice or were threatening to file criminal charges or file police reports, which is not really the process. You're supposed to challenge before the Board of County Canvassers and then follow the appeal process there. That did slow some things down in some places. We also had instances where people were reportedly going places they shouldn't go, touching things they shouldn't be touching, or making duplicative challenges. But throughout that, overall, the Bureau staff conducted themselves in a very professional way, and we were able to conduct and complete the recounts. And then finally, the board did approve several organizations to serve as challenger organizations. In most, as you recall, we talked about the space issue potentially with having multiple challenger organizations. In most cases, I don't think it ended up being an issue. There were some places where we did have to limit it to one challenger per side, but in most cases, it didn't end up being a huge issue. We do have over 100 challenges that made their way to the Board of County Canvassers, then were appealed to the Bureau staff on behalf of the board and have now been appealed to you. So we're going to go through those. A lot of them raise the same issue, so we've tried to organize them in a way that we only have to talk about each issue once. But to try to organize our discussion and get through them in an efficient way, we have kind of put them in 3 different categories for you to talk about. So there's one broad category of challenges that are processes or procedure challenges where they're asking about something that just isn't part of the recount. So we had some where people said they wanted to look at signatures on absent voter ballot envelopes. That's just not something we do during recounts. The recount's about counting ballots. So those are sort of process or procedure challenges where that's not what the recount's about. Then we had others that are process or procedure challenges that affected multiple ballots or all ballots, but are still process procedures that are done within the recount, but which Bureau staff and the county canvassers disagreed with the challengers. So those, again, are process procedure about the way the recount was done, something that actually is done during the recount, and there was disagreement about that process. And then the final category are individual ballot level determinations, where there's just a disagreement about how the recount assistants applied the validity standards to determine whether that ballot should be counted as a vote for one or the other. And those are individual ballots, so the board's just going to have to pull the ballot out and decide what they think is the right answer. I think we'll talk about some of the specific challenges as they come up. The one thing I'll just point out is there were a few challenges that are, saying, why can't we look at more things? Why can't we spend more time? Why can't we take pictures of both sides of the ballot, et cetera, et cetera? There are specific things that we're required to do when we conduct this recount. It is not a broad, wide-ranging investigation of every aspect of the election process. We are recounting the specific races that were requested. And it's whether we want to look at other things or not during that process, we have a specific statutory authority and a specific set of procedures that the board approved for us to do this recount. We also have to do this with taxpayer money. And so, yes, there's a fee for this recount, but that does not, certainly doesn't cover the total cost of what it actually cost the state. And as things were, doing the recount in the way we did them, conducting the recount of the races requested, we needed the full day in all these locations, or most of these locations, to just get that done. So in terms of taking extra days, having staff work extra hours, recount assistants work another day, getting the space for an extended period of time, we just don't have the capacity or the authority to do those extra investigations or things that people were asking for. We are doing a recount, and that's what we completed. Obviously, there are many other mechanisms. If people have additional things they want to look at, they can make public records requests. If they believe there was something unlawful, they can file lawsuits, and courts have authority to do other things that we don't. But the many of these challenges are about things that we're basically asking us to look at other things or do more things that are not part of the recount. And we can talk about that, obviously, as we get into those specific challenges. But with that, we're going to start going through the challenges. To try to organize it, we're going to first talk about challenges that affected both proposals. And then we're going to do, I think, the challenges. Are we doing both first? Is that right? Yeah, we're doing challenges to both proposals first. Then we're going to look at challenges that only affected Proposal 2. And then we're going to look at challenges that only affected Proposal 3. And then we have processes for the board to approve the results pending the outcome of the recount. So with that, I think we have challenger organizations that wish to speak, and I will pass it back to you, Chair Don.
Thank you, sir. Very thorough and helpful. I have one question going back to relatively early, just for my edification and maybe others. When you mentioned the out of balance issue in Genesee County, what you were saying there was when there's out of balance following election, let's say that there's 104 names show on the poll book, but we're only 100 votes tabulated as cast, that's considered out of balance. But you get to the recount process, they open the box, there are 100 ballots in there, that matches, so that is then recountable.
Right, if it matches the number of ballots tabulated on the tape.
And that was why, despite some of the issues in Genesee County, as you mentioned, with out of balance and some of the confusion, once they were able to look into the ballot containers, most of them matched. 19 out of 20, you said?
Correct.
Okay, thank you. Before we start proceeding through this, there are a few names on here people who provided cards and indicate that they're a challenger but with a question mark. And so in order to kind of plan appropriately, I'm just going to read the names, and if you could indicate if you are either a challenger or an attorney speaking on behalf of a challenger. So Philip O'Halloran? You are a challenger? Okay, thank you. John, and I cannot make out this last name. I think it starts with an S. Okay, and are you a challenger? Okay. And then Trish Oliver? You are a challenger as well? Okay, thank you. And if I do miss somebody who is a challenger on one of these items, just please, politely kind of let me know that I've missed you. It's not intentional. I'm trying to keep all this paper straight. So, as Director Brader said, we'll move into the issue of handling challenges related to proposals 2 and 3. And we have 7 of those. And of those, they are divided. There are 3 of them that were into that first category that was laid out by Director Brader. 3 of them related to the second category, and then 1 that will require us to open and make a determination. So, I guess, looking to staff or fellow board members on kind of proceeding through this, I can just essentially lay out what we've got here. We've got the 3 that are in the first. 1 is from Oakland County, and 2 of them are from Muskegon County. 1 is ballot stubs, absentee voter ballot envelopes, and secrecy sleeves are not present or available at the recount. Challengers were prevented from challenging eligibility of voters prior to Election Day and challenging the process the clerk's office used to determine voter eligibility. And as was laid out by Director Brader, those are items that are essentially beyond the scope of the recount. How would fellow members like to proceed on this. This is agenda item number 2, and I have a few folks here that have indicated number 2. Mr. Hartman, are you seeking to speak on this? Yes, sir. Okay. And then, Mr. Brewer, you've put, so I have, according to what I've got before me, there are 2 individuals who would wish to speak on this agenda item. Generally, we bring up the challenger first, and then the rebuttal from the, I guess, I don't even know, opponent, supporter. It's all confusing at this point, but basically it'd be Mark. So, Mr. Hartman, if you would like to come up. These mics are a little different. There's a little guy yelling at the bottom. Make sure that's green. And we'll give you 3 minutes within reason to state your case, and then we'll have questions if necessary.
To be clear, we're addressing the 3 dark gray items at the top of the form?
Correct.
Okay. So specifically, the Muskegon challenges, which are items number 2 and 3. This was a challenge that was filed by Chris Kyla from Muskegon. And Mr. Kyla had, prior to the election, served the Muskegon County clerk with the name of 52 voters who had, from a national change of address, moved out of the jurisdiction more than 6 months before. He was told by Muskegon, citing the Secretary of State manual, pages 17 and 18 of the manual, that the challenger is not permitted to make a challenge to the eligibility of a voter. This is a violation of MCL 168-733, which indicates that is the duty of the challenger to challenge a voter that is not eligible to vote. When this was done at the election, they refused to accept the challenge, and Mr. Kyla reinstated that challenge at this event because those ballots should not have been counted in the recount. And the fact that that challenge was not heard, he believes, is a violation of election law. And I want to just address something that Mr. Brader said in his opening remarks briefly, and he indicated that the scope of this was limited to counting ballots. The statute that I would ask you to, it's in the materials I provided you to look at, is MCL 168, and that is under 872. And that indicates when there is probably a violation of state law that the Board of Canvassers is obligated, both the state and the county level, to conduct an investigation. And I believe that is on page, let me help you find the page number where that statute is actually cited. Page 5 at the bottom is the statute. And it indicates when we filed the petition on behalf of Mr. Allen, we filed a partial recount to investigate violations of law that were stated, and under 872, it expressly indicates, there's an Attorney General's opinion letter on this as well, that indicates that during this recount is the only time there are subpoena powers. The comments were made that lacked the capacity and authority, but there's subpoena powers to conduct the investigation to determine when there's been a violation of law. And in Mr. Kyla's case, he indicated that the process of the election, the mistake made by the Board of Election Inspectors on the day of the election, which is what a recount challenges when you're challenging a violation of law, either by error or fraud, he indicated that had been violated. And he asked that to be corrected. And that is what a recount does. And when he asked for that to be corrected, that was not heard. Related to the Oakland issue, I would ask you to focus merely on the absentee ballot envelopes. This objection was broader than I would have framed it, but I would ask you to note, and I have brought a picture from another county just for demonstrative purposes, of the Secretary of State green seal that goes on the bag. You can see the the seal, and then there's a little card that's sealed to the bag. And I would like to have you take a look at this so that you might be able to understand the reason that this was an important matter for the board to consider. The AV ballot envelopes are certified at every single absentee voter as being present in the bag. This is a check mark that is made by the person who signs the bottom of that certificate. It is a crime to make a false statement, a misdemeanor to do it out of negligence, and a felony to do it intentionally. Every single one of the absentee voter ballot bags that were looked in by challengers around the state lacked the envelopes, and they were certified as being present. So we have a problem. Either those envelopes were removed from those bags, or somebody signed a false certification. And when they were asking to see them, they were able to watch them open the bag and to videotape them. So this is a violation of law that was asked to be investigated, because there is a statute, and it is MCL 168.806A, which requires that that certification be made. And on my document, I've cited on page 8 the seal process and the procedures, and it goes into 806A into 808 onto page 9. The problem is that when we indicate that there has been violations of law committed at the precinct level, and we ask for redress of it under 872 to conduct an investigation to resolve that, we did not get a single investigation. Even though the subpoena powers were granted to this body, as well as the body by the County Board of Canvassers during the recounts to do an investigation, not a single subpoena was issued, not a single investigation was made, and as we go through today, I will continue to point out the violations of law that we're concerned about. So I would indicate, related to Oakland County, the concern is that the AV ballot envelopes were certified as being present, but were not. Secondly, and that's important because those should have been protected, and those should have been part of the seal, and you look at the seal procedures. Secondly, I would indicate that the inability of a challenger to have any meaningful way, because the clerks make the sole determination of the eligibility to vote, and to remove that process from a challenger, as Mr. Kylo points out, under 733 is a violation of the challenger's rights and duties. Thank you. I'm available for any questions.
Are there questions? Okay. Thank you.
Thank you.
Mr. Brewer? I did forget what I've been doing dozens of times. Please state and spell your name for our reporter. She probably knows most of these folks, but it's process, so moving forward, please do that. Thank you.
My name is Mark, M-A-R-K, Brewer, B-R-E-W-E-R, thank you, of the law firm of Goodman Acker. I am general counsel to Promote the Vote. On behalf of Promote the Vote and Promote the Vote 22 and the Reproductive Freedom Ballot Question Committee, we filed this morning a detailed written memorandum responding to each of the challenges in order to assist the board and expedite this matter. I understand that you have an electronic copy of that and a written copy as well. But before I address that and summarize that memo for you, I have some overall remarks that I would like to make for the record. Promote the Vote would like to thank the voters of Michigan for making their voice heard in all the elections that took place this year, and want to thank all the election officials, up to and including your staff, for the very hard work that they did administering these elections, including these recounts. It's clear that the voters of Michigan trust our election processes. They turned out at historic levels this year, and they strongly supported the two proposals that were the subject of these recounts. The petitioners behind these recounts have admitted, and the evidence now shows clearly, that these recounts would not change the result, and they did not change the result. The petitioners have abused this process to advance their own organizational agendas. and we hope that changes will be made to the law to prevent this kind of abuse in the future. Recounts are just that, as Director Brader has indicated this morning, a recounting of the votes cast in a given contest. Recounts are not an opportunity to demand investigations into debunked conspiracy theories rejected by every court in Michigan and nationally. Recounts are not an opportunity to threaten election officials with criminal prosecution because they know the law and are following it. And recounts are certainly not an opportunity to unlawfully handle ballots and other election-related materials. These recounts were initiated by election deniers who are still seeking to overturn the presidential election of 2020. They are not interested in improving elections in Michigan. If they were, they'd be advocating for things like more public funding and resources for election administrators, rather than wasting public funding on a useless recount. The voters of Michigan have spoken. Michiganders are ready to move on to celebrate the holidays, and it's time that the election deniers do the same. Let me address specifically one item that was raised by the opposition here this morning as to this allegation that there should have been investigations of fraud. Unfortunately, he fails to point out that the relevant statute that he relies upon, first of all, relates to the county boards. This was not a county board supervised recount. This was your supervised recount. And that statute also requires that there be probable cause to believe that there was fraud before any such investigation could occur in any event. And the Election Integrity Fund and their lawyers and their challengers failed to do that. They never demonstrated probable cause. So even if an investigation was authorized by that statute, they failed to meet the standards for such an investigation. Now, as to our joint written memo that we filed this morning, we tracked and followed the document that your staff prepared and provided a response to each and every one of them in the same format as you did, so it'll be easy for you to follow. And I incorporate the responses to these specific challenges that are before you on this agenda item by reference to that memo, so we don't need to belabor that point. I remain available throughout the day to answer any questions you may have. I was the lead attorney on site in Wayne County and for most of the day in Oakland County and Jackson County. So I, like my colleagues, remain available to answer any questions. For the reasons I've just set forth, as well as those stated in our written memorandum, we ask that you deny all of these challenges, certify the recounts, and let the people of the state of Michigan move on. Thank you, Mr. Chairman and members of the board.
Thank you. Any questions for Mr. Brewer? Do not see any. Thank you, sir.
Thank you, sir.
I have here also, it was brought up, a Braden Giacobazzi who wants to speak on 2358. Braden, are you a challenger related to these issues we are speaking about right now? Yeah. Which one are you?
But I don't believe that this gentleman made these specific challenges.
That's what you did not make these specific challenges that we are addressing right now, these three, one from Oakland and two from Muskegon. Okay, then we'll bring you up on when you have. Okay. Thoughts? Mr. Hartman?
1 minute, sir, just to respond. The citation that I gave you for 872 is applicable because 901, 168, which is cited right above in my memorandum, indicates very clearly that the procedures for the State Board of Canvassers is to follow the county. And so it is incorporated by reference under 901, and that's in the memo that I provided you. The second thing is, I would indicate that unlike a recount of a candidate, where somebody is another candidate and is able to file that, when a organization such as EIF files a petition for recount asking to redress errors of law or fraud, and we'll talk about that when it gets hit, we get to that, there is no opposition and there is no right of a rebuttal to another side. It's not like a candidate where there's another candidate and they have two lawyers. With all due respect to Mr. Brewer's organization, they did not file a single challenge. And what their means and mechanisms at all three organizations, all they did, sir, Mr. Daunt, was they were interfering with the challengers from EIF who were trying to raise questions of law.
Mr. Hartman, I am not in the habit of agreeing with Mr. Brewer on much of anything. But they didn't file challenges because they don't see an issue with the results at hand. You are the ones who have the issues or purported issues. The burden of proof on your allegations is on you, and it is not before this body.
But EIF
It
is not
is
seeking-
before a court of law where you bring actual evidence. We have been over this multiple times in our previous meetings. This process was to make sure that the ballots, as they were shown as having been tabulated on Election Day, matched. There was minimal difference, as is likely to happen when you're recounting this many ballots. It never had an opportunity or chance of changing the outcome. I think we can sit here and argue about these issues you're concerned about until New Year's. We're not going to do that. What we've got before us are challenges that were made, determinations were made. It's now before us to make a final determination. And aside from the ones where we need to open ballots and take a look and see if we agree with the determination from the locals, these things are outside of the scope of what we're doing. And so we're wasting a lot of time and money arguing about these things.
So I would just preserve one last thing for your consideration, that EIF's position was not about for or against a proposal. Their position was, we were cast that way at the last hearing, but their position was about violations of election law. And that's what is raised. I would respectfully submit that I do not believe that this is an adversarial process where EIF has raised a question of law or procedure for you to determine that Mr. Brewer's organization has any standing. They didn't raise any objections, they didn't file any objections, and they don't have the right to oppose EIF, who has come to the board and raised these challenges. And that's what I would state as far as the procedure today. Because we are here asking for correction of law, not for a change in the outcome of the proposals.
Mr.
Hartman, I just want to clarify something. When we met to approve or reject your recount petition, we went through a whole lot of questions about whether this was a recount or whether this was a fishing expedition to do something else. No, wait a minute, we did. We had that dialogue and we went back and forth. And we went back and forth extensively. And you said over and over and over, no, this is a recount of ballots related to Proposal 2 and 3. That was the scope of what we as a board approved, and there were stipulations that you accepted that went along with that. And so I'm not arguing that you had a challenger that went ahead of the election, that went at election time and talked about 53 names. That's to me, that's completely outside of the scope of recounting a ballot. It just simply is. That seems to me, and I would defer to the attorneys at this table, but that seems like something that if you have a legitimate concern there, that would be a matter of a lawsuit. That would not be a matter of this board taking that up within the context of recounting ballots for Proposals 2 and 3.
Sir, with all due respect, I believe that the enabling statute for a recount of a proposal is different than a candidate. The candidate is under 879, but the recount for the proposal is under 880. And the remedy sought in the petition is to correct violations of law. And so that is exactly what the recount is to do. Please be aware, sir, that I didn't write the statutes, but the statutes give subpoena powers and an obligation when a challenger raises probably cause to believe that a violation of law has occurred, that there is a duty that is then imposed that requires them to follow through and to investigate that. And when they make a determination that there was a violation of law, it's supposed to be referred under 872 to the probate judge and to the Attorney General. Previously,
Again, that's outside the scope of what we agreed to do in our last meeting. What you signed on to and what we agreed to and what we voted on, and I have it here, was a process of recounting ballots within a very limited and very well-defined scope of operation.
correct. And when violations of law were raised, they needed to be addressed.
We talked about your investigative powers and your subpoenas then, and.
We
and
never
those-
resolved it. We took a break, and you never went back to the business of that. We took a break. I spoke to the Attorney General on the right-hand side of the room. When we came back from the break, it was never addressed again.
We resolved it by virtue of what we voted on and put forward as the procedures that would be followed. That,
all right.
end of story.
Okay, thank you.
Did you have a question?
Yeah, I just have one comment to make to Mr. Hartman, and that is with regard to his objection to the rebuttal of his challenge advocacy, and that is that we recognize both Promote the Vote 2022, Promote the Vote, and Reproductive Freedom for All as interested parties in this recount. And that gives them the authority and responsibility to respond to the assertions that you make with regard to your challenges.
Thank you.
As much right to participate as you by virtue of us having you all in here and voting on these things. So, any other questions, discussion, comments? So I believe I'd be set to entertain a motion on these challenges, these three challenges that are pertaining to proposals 2 and 3. We're addressing things that are related to both, and if yours is not related to both, then we will wait. I appreciate that. We're going to try to keep some semblance of order here. So, Mary Ellen?
I move that the Board of State Canvassers reject the challenges which allege that ballot stubs, AV ballot envelopes, and secrecy sleeves were not present or available, that challengers were prevented from challenging the eligibility of voters prior to Election Day, or that the process of clerk's office, that clerks used to determine voter eligibility should have been considered in the recount. So I move that we reject those three challenges with regard to Oakland County, Muskegon County, and both Oakland and Muskegon counties.
I'll second that motion.
We have motion and support. Is there discussion? Before we get too far down the road from a staff perspective, is that motion acceptable and get the work done? Okay. All right, so all those in favor of the motion signify by saying aye. Aye. Any opposed? Motion carries 4-0.
Can I ask you one question before we do the next?
Sure can.
And this is maybe more toward Jonathan and Adam, do we need to expressly give you a reason? Do we have to articulate that in a sentence? You had a piece on the spreadsheet to record that?
I don't think, do you think we do?
Okay.
I don't think so.
I don't think so, as long as it's clear what challenge like you're talking about, just so I can make it clear when we're doing the minutes.
Okay. Because definitely want to be transparent as to what we're rejecting. I think that's why it was laid out like this, so that we can get through these. Everybody knows what's going on, and there's no question. You may disagree with what we're doing, but at least you're aware of what we're doing. With that,
May I ask, is this the form you're using? Can you just number them, 1 through however many?
Yeah, so the document you have is the same document the board has in front of them right now, and we're going in order of those.
Yeah,
Down, so if we want to number it,
I would be okay with that if my fellow board members would be okay with that, so that as we look at this, this would now be challenge number 2.
Are you going by block?
Blocks, yeah, blocks of. I'm going by blocks of, so what we just did, this block of dark gray would be 1. This next 3 in white would be 2. And then the last one would be 3, and that would be it for what deals with both proposals. So my suggestion then would be, as we move on to the next block, that's something, those are related strictly to Proposal 2. We would begin with number 1 on that for that agenda item. Does that sound sensible to, yeah, barely sounds sensible to me as I walk through it, but trying to make this easier so we don't have to read out every item moving
Well-
forward.
I would suggest then, since we have all of these listed, that we number them 1 through whatever, 1 through 119, so that we could efficiently, instead of trying to frame the motion as I just did, if I could say that I move that we reject 1, 2, and 3, I think that that would be, for the record, which Mr. Hartman may want to challenge later on, I think that would be the most efficient and clear way to proceed.
I think that's wonderful.
So let me reiterate my prior motion.
Okay?
I move that the Board of State Canvassers reject challenges 1, 2, and 3.
I second the motion.
We have a motion, we have support. Any discussion? Okay. Any concerns from staff or legal on reiterating in this fashion? Okay. All right. All those in favor of the motion signify by saying aye. Aye. Any opposed? Motion carries 4-0. Under this newly established Gurwitz rule, Hartman-Gurwitz rule, we'll call, these are numbers 4, 5, and 6. And these are items,
So,
I've pilfered through my paper here.
so these are procedural challenges, but it requires opening the envelope to look at what's inside to resolve them. And they're sealed, so we couldn't open, right?
we can now.
Yeah, but we didn't previously because they're sealed.
Okay, so these are procedure, but they do still require us to open, okay? And they are, all 3 are from Muskegon County. And this is need to open abuse, it says it right there.
Basically, we did.
This is still agenda item 2. Why don't we bring these, hand them down, we'll open these and see what we're looking at.
Yeah, so we don't know, the process challenge is not apparent to us from just looking at the outside of the envelope,
So
so we
my
need to open them.
suggestion is because they may be different, I'd say we would probably just hit one at a time.
Okay?
So what procedures do you want to do about opening these?
I think probably best just to have me unseal it, so everybody sees me doing it, and then pass it around. They appear to be, this first one, challenge envelope exhibit number 15, County Muskegon, process challenge inside. Ruling by the County Board of Canvassers is to reject the challenge. The ruling by representative of Board of State Canvassers is reject. To be appealed, yes, and this is signed by a representative of the Board of State Canvassers, which would have been the staff that was there participating in the process. It is sealed.
Forgot the letter opener.
Did forget the letter opener.
Sure.
I don't think we can.
Can we put a sticky note on it? Sticky note or something? Let me see if I have any.
This one, I protest denied viewing of both sides of the ballot protest for the whole recount. I protest that I am not being permitted my rights under MCL 168.874 to observe each ballot, to have an opportunity to review for this 803 parentheses 1 or 795 parentheses 2 protests. Limiting exposure to one side of the ballot is unlawful. I can read the whole thing if people would like me to, otherwise it's essentially a reiteration of some of the things we've heard. And it is signed by Christopher, I think that might be Raymond, and, I'm sorry? Christopher Kyla, okay. And then is Christopher here? I will speak on his behalf. Okay. 1 minute.
I have memorialized this on page 3, item number 4. I have cited that, once again, 891 indicates that
The memo he gave us.
submitted by the Board of State Canvassers. It references section 861 at SEC, and then we cite 874, section 3. It says a candidate or person interested in the ballot question, their counsel, watchers, talliers.
Oh, yeah. Thank you.
Apologize. 168.874, parent 3 indicates the candidates or persons interested in the ballot question, their counsel, watchers, and talliers shall be allowed to observe each ballot as it is called and take notes as they desire for their own records. And it was indicated that during this recount, some of the reasons that were cited, because this issue will probably need to be ruled on one time because I believe it'll be duplicated in other portions. So I'll make the argument once so we can move through it. As you rule on this one, I assume that will control if it comes up again in a later challenge. The reasons cited by the challengers as not being able to see the front of the ballot were, number 1, the law permits it. Number 2, the front of the ballot identifies both the precinct and the ballot type, and to make sure that it was the right ballot in the right ballot type. Number 3, a ballot with the word written duplicate on it is noted on the front side of the ballot. And then there was a process by which duplicate ballots were to be compared to the damaged ballot. A ballot that has tape indicating a challenge has previously been filed would be only on the front of the ballot, because they would write the ballot number on it to match the poll books and cover it with white tape. We weren't allowed to see that. And MCL 167.8031, which specifically requires the ballot with distinguishing characteristics during a recount, would be deemed void. You would not be able to see if somebody had made a distinguishing characteristic or mark, and therefore the challenger would be unable to comply with 8031A. Last, a ballot with an overvote that has been processed by the voting system and not rejected in violation of 168.795, which requires rejection of the voting system, and that would require a hand count of the ballot. There would be no way of determining without being able to see the front of the ballot if the machine were programmed in violation of MCL 168.795-2. I have on section 4 of my objection on page 3, and it goes on to page 4. Under that objection, set forth the law, which indicates, and it is our belief, that the inability to observe the front of the ballot and to make notes is a violation of the procedure of the recount. And that was done pretty much universally in the process of this recount.
Thank you.
Thank you. Any questions before I move?
Are there questions? Mr. Brewer, you were moving as though you would like to come up. Come on up, sir.
Thank you, Mr. Chairman. First of all, on the merits, there's nothing in the election law that authorizes or requires in a recount situation like this that the entire ballot be viewed. The statute gives them the right to view the side of the ballot on which the proposal vote is cast. That's the sole focus. There's nothing in the election law to the contrary, and we urge you to uphold the decisions here. If I may, Mr. Chairman, I want to raise a procedural question, though. I thought Mr. Hartman had exhausted his 3 minutes. If we proceed like this, we're going to be here through tomorrow. So It's the board's discretion. I respect that. But Mr. Hartman had his 3 minutes. I'm happy to be done with my 3 minutes, but if necessary, I'll be back up here to respond to him every time. Thank you, Mr. Chairman.
Understand, I'm trying to be respectful and give people a chance to speak, and then we'll hopefully be able to exhaust some of these arguments and move forward relatively quickly, but appreciate that. Trying to respect everybody's time. You can come up if you want.
He's jumping in his.
Just on this procedural, if
Mr. Chair, may we have our
Yep.
speaker, please?
Chris Trebilcock, I'm an attorney at law, TREBILCOCK, representing Promote the Vote 2022. And I just note, in terms of these challenges that we're going through, there's a process. And at the last meeting we were here, we recognized interested parties who have standing in this process challenge. The individuals who made challenges at the various recount sites did them on behalf of the interested parties. They do not have individually have standing. Rather, pursuant to the Bureau's board notice, it's the interested parties, and then the attorneys were limited to 3 minutes per side on behalf of those interested parties. So I would argue and urge the board to consider that as they're determining their procedures for today. It's the interested parties on both sides, and then whatever procedure you want to use to allow the interested parties to address each challenge. I believe the procedure that was set forth was 3 minutes per side, per group of challenges, per agenda item. We're more than willing to respect that and think that that's adequate. Thank you.
Thank you. Do you have a question?
Mr. Chair,
Yes, go ahead.
for efficiency, I know I said we'll do into the, so I guess my curiosity is if the other two are the same challenge.
I would imagine that to be the case, so why don't I open them?
Yes.
And we'll take a look at them, and then we can proceed.
Thank you.
I did not, I put a little sticky on them. So this one goes back in here. This is related to electronic voting systems, so I guess that is different. Signed by the same individual.
And we're identifying this as challenge.
That's number 5, yep. And then this is challenge number 6. The legality of absentee ballot signatures has not been determined pursuant to MCL 168.766. So again, different. Number 6 is different. They're all different, but I think in my determination, in my understanding is these are all process. They are all related to things that are not open for challenge or discussion or changing the way things were done based on what we discussed and voted to approve moving forward for the recount at our previous meeting. So in my opinion, each of these should be rejected for that reason. Now, I think because they are numbered, because what we would be rejecting would be consistent with what we approved, I don't see a reason to handle them separately, but open to other interpretation of that. So again, we're on numbers 4, 5, and 6. Those back down. So, I think I would be entertaining a motion, or would staff anything Ken?
Mr. Chairman, I move that the Board of State Canvassers reject challenges 4, 5, and 6.
Mr. Chairman, I'll second that.
We have motion and support. Do we have discussion? All right, all those in favor of the motion signify by saying aye. Aye. Any opposed? Motion carries 4-0. We are now on the item number, challenge number 7. This is a challenge related to a bleed-through and use of marker and stray marks. It is something that is going to require a determination from us on whether we agree with the recount team. So I will open that. We will take a look at this, and then we will make our determination and a motion. I don't envision a need, because this is simply something we are taking a look at to see if it matches the procedures and confirming or denying what they did. I do not see a reason for attorneys to come up and speak about this. Yep. And this is challenging decision because believes the ballot is invalid due to bleed-through and stray marks. And I'm looking at so what it would appear to me is they are saying that these votes on the proposals, so here 2 and 3, very clearly this individual has voted yes. They've fully shaded the box. There is bleed through from what they did on the front into the back, but it does not impact their marking of their yes vote. And I would, in my mind, would reject this challenge because, again, human eyeballing this will tell you that it's very clear this individual wanted to vote yes. I don't think any of us want to be in the business of throwing somebody's vote out because of some Sharpie markings on the other side.
Can I ask a couple questions on that?
Sure.
Can I look at it?
Yep.
The bleed-through has been an issue that's been raised a couple times by different people, the Sharpie bleeding through. Am I allowed to hold this up?
Sure. Yeah.
So what's happened here is, without having you see more, is that the bleed-through is coming 2 inches away from the boxes that are being checked for an actual voting action. And my understanding is that the machines are calibrated to read only the position where the boxes are. So if there's a bleed-through, that's not something that the voting machine is reading. Is that correct? Is there anybody that disputes that?
I believe that's
That's
correct.
correct.
Okay, so that's question number 1. So that would not change this ballot. If there was a bleed-through, it doesn't affect it. The second question is that if there was a challenge, if there was a problem with the machine, am I also correct in assuming that rather than being counted on a bleed-through, this would, if the machine had a problem, it would reject it, correct?
Correct.
Which on the tape would show that it was a rejected ballot?
Well, it would, it depends. So
Okay.
if the entire, if it read the bleed-through in a way that it thought that the races were overvoted, it might reject the votes for those races. But if there were still votes that was able to read for other races, and the overvote, assuming this was an in-person ballot, was still accepted by the voter, or in the case of an absent voter ballot, if the election inspectors counted it for the ballots for which there was no overvote, then it would still record votes for those races.
Okay, okay.
And generally, this type of thing will happen with an absentee because they send it in, they are not there when it's processed. And so because when you put something into a machine while you're there, it'll push it back out and say, hey, you did something wrong, take a look at this.
So, yeah, I mean, if somebody brought, so in this case, I don't believe the tabulator actually rejected this ballot, so it didn't cause a problem for the voter. I think what the challenger is saying is that even though the tabulator accepted it, it should not be counted because of these bleed-through marks. But in the case, you know, it is, in the case if you were in person and it did reject your ballot, it would come back out and you would have the opportunity to vote, spoil that and vote a new ballot, or if you just didn't care, if your vote didn't count for that race, then you could accept it and it would still go in if you were in person.
Chairman Dodd, may I have 1 minute? Thank you, sir. Sir, that ballot was challenged as a demonstrative.
Microphone, Mr. Hartman.
That ballot was challenged as a demonstrative. It is folded, so it is obviously an absentee ballot because a in-person ballot would not be folded. The adjudication software allows the machine to read that ballot. We do not know how the ballot is programmed, whether it would have read it or not. I believe the objection is on the basis of the use of a Sharpie. Why are we doing that? This was an absentee ballot, but in-person precincts are using Sharpies, and there are lots of bleed-throughs that were identified through this recount. We do not know whether the machine, both the tabulator that is at the precincts has an override button that you can accept the ballot if it has an overvote, which is a violation of 795-2, as well as the adjudication process allows it. I believe the objection and the spirit behind this objection is that we should not be using a Sharpie. It should be part of the instructions for this very reason. In this ballot, they do not line up, and that was the objection.
Mr. Chair, I just have a question.
Please.
I should have said that before Mr. Hartman spoke. The signature on here is, the challenger is Leah, P-O-V, I hope I have that the right way, but wouldn't it be proper that that individual who challenged this at the county board be present at the state board? Maybe that's a question for Director Brader.
Well, in the notice, we indicated that the challenger could be present or the attorney on behalf of the challenger or the organization. So according to the notice,
Okay.
that, I mean, and the board obviously
Got it.
can determine that, but.
Mr. Chairman, I agree with your assessment and that of Mr. Hausman. This does not in any way affect the validity of the vote, which is evident from the ballot.
Is it possible for us to look at bleed-throughs in general? There are a number of them through this document. Is it possible to simply put all the bleed-throughs into one basket, if you will, and maybe that's not doable, but.
I think because you're talking about on down
Well,
the
you've got-
road here,
Yeah,
those are a separate agenda item.
okay.
And so I think it will help us,
So
it'll help guide us as we move forward and should cut down on some of the discussion.
Okay.
My only concern, Mr. Chair, is that we do have to remember we have 3 voting systems in the state of Michigan. This is obviously a hard verity system with the rectangle, and I just want to make sure if we saw those in the Dominion or the ES&S that are ovals. I just want to make sure that we look at those. I mean, the way that each county sets up their ballot, I would feel that would probably be proper for us to open those, just
Oh,
to.
absolutely. Regardless of what the decision
Yeah.
on this is, on this issue, we will open each of those items. So I would entertain a motion on challenge number 7.
Mr. Chair, I move that the Board of State Canvassers reject the appealed challenge, which alleges that there was bleed-through and the use of marker and stray marks. Number 7, I'm sorry. Let's make it easier. All right. Mr. Chair, I move that the Board of State Canvassers reject the appealed challenge to number 7.
Okay?
I'll second that.
Motion and support. Any discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Any opposed? Motion carries 4-0. That concludes agenda item number 2, as we have reviewed the challenges. We are now on to agenda item number 3, consideration of pending challenges appealed to the board in the partial recount of proposal 2022-2. There are just a few of these, it would appear, as the majority of the remaining are related to proposal 3. So it would appear that there are 1, 2, 3, 4, 5 that appeal items related to proposal 2. Those will be numbered 8, 9, 10, 11, 12. All of them are from Macomb County. They fall into the second bucket of process and procedure. Are there items related to these that need to be opened? No. Okay. So, they would appear to be quite related to what we've already discussed. I have Mr. Hartman, I'm assuming, to speak on these items. Please address them all together. 3 minutes, and legitimately 3 minutes. I'm going to start.
Oh, there is a timer.
Yep. Timer is going.
Item number 8, you've already ruled on that matter. It was re-raised on this issue. As to 9, 10, and 11, when a precinct is unrecountable, it means a violation of law has occurred. There are 3 ways a precinct can be, and I have set forth the process in my memorandum for you. And it indicates, let me give you the specific point. This would be item number 8 on page 9. I'm sorry, item number, okay, so I'll address this briefly. When a precinct is unrecountable, it means that it was not properly sealed or it was out of balance. There are statutes which require that a ballot box be properly sealed, and there are requirements that say in 801 that the duties of the election day precinct inspectors is to make sure it balances and to stay there till they do. And when it is not balanced, they have violated their statutory obligation under 801, and it's a violation of law, and a full and complete investigation should be done under 872 because there's probable cause. Specifically, as to item number 10, Shelby Township 27 AV, what's extremely disturbing about that one is that was 100 ballots exactly less than the tabulator reported. So when you look into the details of that one, there were 668 ballots, I believe, reported, and there were only 568, so it was deemed not able to be recounted. Despite the missing 100 ballots, this was certified by the Board of County Canvassers and by this board on November 28th. We believe a full investigation should have been done whenever a precinct was unrecountable because it indicates right there that there's been a violation of law. It would either be under 24J for having an unapproved container, or a violation of the seal procedures, which start with 765 parent 6, carry forward to 801 through 806A, and all the way to 823 at the Board of Canvassers. So when there's a problem with the seal, somebody has violated Michigan law. And there needs to be an investigation as to whether it was inadvertent, accident, what the circumstances were. The harm was there was no recount. And 6% of the precincts, as stated by Mr. Brader, weren't able to be recounted is unacceptable. Thank you.
Thank you. Mr. Trebilcock?
Chris Trebilcock on behalf of Promote the Vote 2022. We'd like to thank the chair and the rest of the board for your time and dedication shortly before the holidays or during the holidays, as depending on how you celebrate. like you, we'd all like to be somewhere else, home with my kids who are home from school. But perhaps more importantly, I'd like to just thank the Bureau staff, those who are here and those who are not. They were the consummate professionals at all locations and often under difficult times. And I think we ought to recognize all the local clerks who dedicated time and resources away from their municipalities to show up and dedicate staff time towards this recount. They were very helpful, and in the face of threats of prosecution and accusations of doing unlawful things, and in some cases, just unpleasant shouting and things being said to them, or you know, people up in their space and cameras up in their face the entire day. And they just did a tremendous job, and so we'd like to thank them for that. I draw the board's attention to our submission, and that the board consider in consultation with staff and council whether that there's a number of these 119 challenges, whether or not they're properly preserved for appeal to this board. There were a number of those that sought relief that could be or could not, or I should say could not be granted at the county level, and therefore is something that could not be appealed to this board. And we noted that in our cover letter, in our memo to you, and so there may be some ability to strike a great number of these. And it really comes down to, you know, I feel like we should be in front of the Board of Education, because I think some of this process could have been avoided, and the challenges could have been avoided by better education and experience by those seeking to challenge. Because if they would have reviewed the manuals put out by the Bureau staff on what occurs during a recount and the recount process, and what a stray mark is, and why precincts aren't unrecountable, and how, for example, seals can just be broken because there's 5 bags that get put somewhere and a seals rub next to each other and they break the seal. If you've been through the process, you see these things. There's nothing nefarious going on. In addition, I think if you look at the county board level, when they talk about an investigation, many times when these precincts were out of balance, an investigation did occur. Joe Roselle down in Oakland County, where I was, they looked into it, and they had precincts that initially were unrecountable because they were out of balance, and they looked into it, and they figured out why it was out of balance, and they were able to conduct the hand recount. So the process worked. So again, we rely on our written submission. We'd encourage the board to review these procedural challenges that are not properly preserved for appeal, and reject these uniformly. I'll be here available as my colleagues for any specific questions, but again, we urge the board to reject all these challenges affecting Proposal 2. Thank you.
Any questions for Mr. Trebilcock? Okay.
Mr. Chairman, I have a question for Mr. Brader. You have provided us with all of these challenges and suggested that we need to address them. Mr. Trebilcock has said that a number of them were not properly preserved for appeal. Can you please advise us whether there are challenges which we should not need to consider?
So in putting this list together for you, we did not identify, Bureau staff did not identify any that we presented to you that we didn't think were properly before you for appeal. I would obviously defer to the Attorney General's office if they believe there's a legal basis for saying that they were not properly preserved, but that's not a determination that we made.
Come on out, Steve. Turn the mic on, state, spell your name.
Thank you, Mr. Chairman and members. Stephen Liedl of Dykema, appearing today on behalf of Reproductive Freedom for All. Apologize for taking more time. It may save some time in the end. I do think it's appropriate that the board consider both the statutory requirements related to challenges and the procedures that you, the board, have adopted, and consider with each challenge whether or not, under the statute or your own rules, the challenge is even properly before you. 2 quick points on that. I'll point to the third paragraph on our memo that we submitted. Section 871A of the election law speaks to a proper challenge, right? And it says that if a proper challenge is raised by a candidate or an elector interested in a ballot question during a recount, the local board of county canvassers shall resolve that challenge before the recount is completed in that county. So if you have any relief before you that requests action by anyone other than that board of county canvassers on the day of the recount conducted in that county, there's no statutory authority for it to be treated as a, quote, proper challenge. It would be an improper challenge. So I think you have the ability, when any time a challenge requests action by anyone other than a county board of canvassers at any time other on the day of the recount before the county portion of the recount is completed, to not consider that as an improper challenge. Secondly, under the procedures that the board adopted in another category of challenges, the challenge is supposed to be detailed at the time it is made in real time under your procedures, and then it has to be reviewed by the challenging person or entity and signed. And your own procedures do not provide for any sort of supplementation or additional arguments or additional challenges relating to that. So I submit to you that you should only consider the written materials that were presented under your procedures and signed by an individual. And if those information do not appear on the outside of an envelope signed by the individual as requested, you should not consider anything. And it also means that you shouldn't take any time to consider additional information or arguments relating to a challenge other than information submitted under your own procedures. Your procedures do not provide for supplemental challenges. Thank you.
Any questions? Okay.
Mr. Chair, I would like to see what we have from the Bureau.
Okay.
Sorry, I just want to make sure you get the.
That's okay.
These are
This
items.
envelope that I'm handing you relates to challenge number 8. That's challenge number 8, the envelope associated with it.
What number is that?
This is number 8, not able to view front side of the ballot.
Director Brader, the challenge that we have in front of us does not have a seal, obviously because it doesn't have any document inside of it. So is that properly presented to this board?
It doesn't have to be in an envelope. We use the envelope when there's a ballot in there, so that's not a requirement for proper presentation.
So this essentially just used an envelope to state what their challenge was. There is no ballot in here. So,
Correct.
Are there envelopes?
Mr. Chair, looks like we have statements.
That's 9 and 10.
9 and 10.
These are 9 and 10 and 11, precinct unrecountable one investigation. I think we've been over this multiple times.
12 is on that list, too.
And 12. So I think, again, we're
Can I ask one question?
Mr. Chair, can I ask I'm sorry, Richard, do you mind if I ask?
you want to go, do you mind if she goes
No,
first?
go for it.
I've been actually kind of quiet this meeting. And I apologize because I've been around a lot of people who apparently I may mask in the middle of this meeting. I'm just letting you know that. Procedure, can you go over the procedure of challenge at the county board? I've been at recounts. I've seen the challenges at the county level, but I'd like to have Director Brader kind of explain how that happens, because obviously we're just getting statements. I'd like to make sure that we're all, there might be people who have never been in this process before.
Sure. So in the course of the recount, if a challenger wishes to make a challenge to a process or procedure or to an individual ballot determination, they do that by filling out a written statement that indicates what their challenge is. And that is either done on an envelope, definitely in an envelope if there's a ballot involved, or on a paper form. That written challenge is then secured, retained. It's presented to the County Board of Canvassers first to determine whether they agree with the challenge to the recount assistance determination or to the procedure. If the county board rejects that challenge, the individual can then appeal that same written challenge to the Bureau, to the Board of State Canvassers representative, in this case, the Bureau of Elections. And then if they wish to appeal that determination, they can then appeal it to this board, which is the ones we have today, are the ones that have been appealed to this board.
Thank you, Director Brader.
I'm of the mood that I think a motion would be in order on items 8 through 12.
7, I think, right? Oh, no, sorry, you're right. I'm sorry, 8. My fault.
I'm struggling, but not struggling that bad.
I'd still like to ask Mr. Hartman a question.
Oh, yes, sorry about that. Go ahead.
Mr. Hartman, if I could. It's a pretty simple one. I'm looking at the reasons why these precincts were uncountable, or why these precincts were unrecountable. And the question is do you know if the clerks in those counties had already addressed the fact that these were unrecountable?
So in every case, an investigation was asked for to the Board of County Canvassers to make determinations and findings of fact and determine if there was a violation of law. Because it was recountable, we believe that established probable cause. In 0 cases throughout the state where 6% of these precincts were deemed unrecountable for violations of law, was an investigation conducted.
I think I'm asking a different question, though.
Okay.
The question I'm asking is a little more human. It's not law.
Okay.
The question I'm asking is, in each of these counties, there was a county clerk that at some point in time, and a Board of Canvassers in the county, and a representative of the State Board of Canvassers, who recognized that a precinct was unrecountable.
Agreed.
Agreed. So in each of those cases, was that like a huge revelation that the county clerk said, well, we're going to stuff this somewhere, we don't care, or we're not going to look into it? What I'm interested in is, in each of these cases where something happened that made it unrecountable, and there's different reasons, seal accidentally broken, recognized by the county clerk. These are human errors. These are things that happen. So in each of these counties where there was an issue, in each of these precincts, it's not a matter of was the law broken. It's a matter of did the county clerk look into it? Was there something put on record that said, yeah, you know what, we broke a seal, everybody paid attention?
Nothing was put on the record, sir. Let's talk about the broken seal. The seals were described to me by the Board of Elections worker that I was dealing with. I observed them being hacked at in order to cut with wire cutters, because the seals that are approved by the Secretary of State through the process don't break accidentally, okay? So when somebody makes the claim that a seal just broke because it rubbed against something, that is ludicrous, and it needed an investigation. What happened is somebody broke the seal on the box. The Secretary of, the rules of the law, regardless of the procedures, states that there is a person who's responsible for making sure it's sealed and a person who's responsible for safeguarding that seal. And what is the consequence? The consequence is, in some cases, it becomes even a criminal statute. I didn't write the law, and I'm not out here trying to lock people up. But the matter is the law was broken, and we asked for an investigation under 872.
Question
No
still comes
investigations
back
were
to,
done.
the county clerks are the ones who dealt with these issues in real time as they occurred. That's a yes or no
No,
question?
that's not what occurred. The Bureau of Elections worker would go from table to table, multiple tables. There was usually two of them at the recounts that I observed. And when they were made a determination, there was three reasons. One, the bag wasn't approved, which is a misdemeanor for a clerk to use a bag that's not approved. Number two, a problem with the seal, or sometimes the zipper was open, or the ballots were not secure. That would be a second reason. And the third reason was after they did the initial recount, if the ballots didn't, like in Shelby Township, where there were 100 fewer ballots than the tabulator reported or the poll book reported. So in those cases, they said, we can't recount it because there's obviously been a loss of ballots or a breach of ballots, or there's a non-reconciliation. My point is, and I believe the point of the challengers was, it's not enough to determine that there wasn't a recountable issue, but determine the facts and circumstances and to make a full and complete investigation. That was not done, and it is still your duty to make a full and complete investigation when you have the subpoena power here today. And that is our assertion. And we won't have to re-argue this. I mean, however you guys decide to do it, whether you're going to say that there's no way for a ballot box to be unrecountable unless there's a violation of law or not, is a determination for you to make. And I've preserved it. And just to give Chairman Daunt some relief, on the next section through 26, there's only two unique items there that I'm going to comment on that we haven't seen before, so this will move along pretty quickly. But I think it's a watershed moment for this board to determine whether or not you would invoke those responsibilities under 872 or not.
Did you have a question or comment?
Yeah, I think that we have said repeatedly that the function of a recount is to determine whether the tally of votes was correct. We are not going to, we have no responsibility to, and no authority to do the kind of investigatory work that you are urging upon us. That even if your reading of the statutes were correct, which I think they are not. So I would just urge you to stop imploring us to do things which we have no ability or responsibility to do. And let's move on. It is 11:15. I don't think any of us want to be here. We can be here till 4:30, but let's try to get this over sooner. And recognize that you are not going to persuade us that we should be issuing subpoenas or doing investigations. That is not our job. And we've heard you, and if you want to go to court and argue that we have not fulfilled our responsibility, have at it.
Thank you.
Mr. Trebilcock.
Briefly, I just want to again go to the standards that are included in the statute, which requires probable cause. There's no evidence of probable cause of some sort of fraud. They say just because a precinct is unrecountable, it's per se demands an investigation. That is not the standard in the statute. I'd also note for the record that at least one of the clerks, which Mr. Hartman challenges, is Stan Grott in Macomb County. And the one with 100 ballots missing is Stan Grott, well-known Republican, who's challenged a lot of these same things. And if he believes that there was fraud or illegality in Mr. Grott's jurisdiction, there's a county prosecutor, former Senator Mr. Lucido, that Mr. Hartman can petition to investigate Mr. Grott, and that would be where that avenue lies. So I'd encourage him to do that.
Thank you, sir. Gentlemen? You can put the hand down. I'm not going to recognize you, so. Again, on items 8, 9, 10, 11, 12.
Mr. Chairman, I move that the Board of State Canvassers reject challenges 8, 9, 10, 11, and 12.
I second that motion.
Motion and support. Discussion? Seeing none, all those in favor of the motion signify by saying aye.
Aye.
Aye. Any opposed? Motion carries 4-0. Based on my reading, that concludes agenda item number 3, which would take us to agenda item number 4, which is the certification of the partial recount of Proposal 2022-2. Director Brader, anything to add to this? Is there anything special about what we're doing essentially, or is it just essentially we are saying recount occurred, we recognize the results, nothing changed in those results, end of story?
No, I mean, because the challenges were rejected, the adjusted vote totals as a result of the hand recount are basically being certified by the board now. So this will change the vote totals by a net of 6 for this proposal, and we'll subsequently update that on the official website.
Thank you, sir.
You want to add? Just, Adam's going to
So just,
explain it better.
just to be clear, what's in your packets under tab 4, you've got, and what is posted online as well, it reflects the final numbers. So if you accept the challenge, we will have to adjust the numbers from what's in your packet, if that makes sense. And then we, on our website, will compile this from the counties to have a total number overall. The Director Brader did read what that is already, but we will be putting that online as well.
Thank you, sir. So, agenda item 4 would be seeking a motion on certification.
Mr. Chair, based on the examination of the partial recount of the votes cast at the November 8th, 2022 general election regarding Proposal 2022-2, I move that the board certify that the attached is a true statement of the votes given in the election. I further move that the Board of State Canvassers certify the state Proposal 2022-2.
Passed.
I'll second that.
Passed, sorry.
I still second it.
Okay. Motion and support. Any discussion? Seeing none, all those in favor of the motion signify by saying aye.
Aye.
Aye. Any opposed? That motion carries 4-0. That concludes agenda item number 4. Halfway there. Agenda item number 5. Consideration of pending challenges appealed to the board in the partial recount of Proposal 2022-3. That would be challenges 13 through the rest. I have not numbered them, but in terms of the various blocks that are before us, and
13 through 26.
thank you. I was trying to talk and write numbers. So we are on 13 through 26. I'm going to take a wild stab that these are things we've already discussed today and at previous meetings. I think this board, number one, the staff has done phenomenal work putting all of this together for us to review and look at. And reminder, we get this a little bit ahead of time, but because we're a public body and this is an open meeting, we don't talk to each other about this stuff. We conduct these things in these meetings, so we're working through this the same way many of you are. I, as chairman, and the rest of my fellow members want this body to be open and transparent and give people an opportunity to state their case, but at some point we reach rapidly diminishing returns on some of this. We've been over these things numerous times. I think we're going to have the same arguments. I know that there are items that we need to open, and I think we want to get to those and do that because that is required of us. But frankly, 13 through 26, and then 27 through whatever that would be. I don't see value in having an hour of back and forth on this. Which one is that?
What is, can you read that?
Can you please use the microphone?
Yeah. come on up. I will give you 3 minutes on this, and then Mr. Liedl, I believe you're here on this one. Let you come up and address.
So 13 through 26, I would indicate that the board has already made a precedent as to how the rest would be decided except for 18. In that one, it indicates that the Board of Canvassers lacked a quorum. There was only 2 people present for Grand Traverse County. And how the board wishes to deal with that, that was what the objection was, that there was not 3 members of the Board of County Canvassers present.
Were the 2 members of the board, just out of curiosity, were they separate parties, or?
I wasn't at that board, I'm not certain. But the other ones, I believe, would be, you have already made a determination and heard discussion on.
Thank you. Mr. Liedl.
Thank you, Mr. Chairman and members. I'll be brief. Enforcement of the Open Meetings Act and requirements for a quorum is not a responsibility or duty that the legislature has chosen to vest in this board. Certainly, if there is an issue with the quorum, there is a mechanism under the Open Meetings Act at any time for the board to meet again and remedy any violations of the Open Meetings Act. But I don't believe this board has any authority to deal with quorums or lack thereof at boards of county canvassers. Thank you.
Thank you. As somebody, it looks like Jeanette, you are going through and numbering these, so we'll give you a touch more time to do that. These attorneys were a lot more brief than I thought they would be, so thank you. So
85.
27 through 85. That is what we were
Sorry,
addressing
Chair,
right now.
we don't think we had a motion on 13, starting at 13. And then,
I'm sorry.
We need to make a motion on 13 through 26.
I mean,
Yes.
you could also do 13 through 85 if you prefer. We just organized it that way for your convenience.
I think it makes sense because it was laid out a certain way to stick with that and do 13 through 26.
Mr. Chair, I move that the Board of State Canvassers reject challenges number 13 through 26.
I will second that motion.
We have motion and support. Any discussion? All right, seeing none, all those in favor of the motion signify by saying aye. Aye. Any opposed? Motion carries 4-0. Moving on. Now we are on numbers 27 through 85. And these are that second bucket, which is related to process and procedure. Again, doubt that there's going to be much in the way of new information. In the interest of fairness, consistency, if you would like to speak about that for a brief moment, I will invite you to do so. And also, because I had mentioned this prior, I want to address it right now. These individuals who are challengers listed here on, looks like most of them are item 5, some put number 8. With the attorney, Mr. Hartman, being here to discuss this, I want each of you to have an opportunity to speak, but I think it makes sense to put you in the public comment section at the end. So I'm not skipping or ignoring. When we get to public comment, I will invite you up to speak. And so I just wanted to make note of that. Mr. Hartman, please go ahead.
Chairman Down, I will limit myself.
Microphone.
Chairman Down, I will limit myself to items that have not been discussed previously. Your Honor, or your honorable board here, on item number 27 in Genesee County, that was requested that the ballot appears to be blank, wants an investigation. I would just ask whether or not that ballot is in the envelope for the board to look at. 28 appears like it needs to be looked at. It appears that the challenger is making the statement that the ovals were printed on the ballot. That was their observation. I have not observed that ballot. 29 is an issue related to a violation of law related to duplication. Duplication is covered by 168.798A. Indicates a duplication is to be made if a ballot is damaged and unable to be read by the machine, and an exact duplicate is to be made. I do not know what the error is on number 29. Moving on to item number 31 through, I guess, 35, which is challenges to the location. I have placed that in my formal comments for you to look at. There was objections that were brought because the proceedings were moved out of county to be combined. This is claimed to be a violation of law. The law that is cited was in the third objection on page 3, 168.899. The statute states, all recounts provided in 878 et sec of this act shall be conducted in the several counties where the votes to be counted were cast by the respective boards of county commission canvassers in each of the several counties. The reason that this became an issue is because when there was time that people were disenfranchised because they were unable to travel, or because host police officers were unwilling to investigate issues that were arising related to counties that were not their county, and sheriffs and police that were from a host county were unwilling to travel into another county to do an investigation. But the basis of the changing location issue is a procedural process that was used, that was objected to in multiple locations. Related to 36 and 37, they're claiming the ballot appears to have been printed, and meaning that it is a machine that filled in the ovals, and they've requested investigation on those. There's the duplication error issue that needs to be addressed when we're unable to find the original, and could not make a determination because the ballot was marked duplicated and there was no original. I would direct your attention to the fact that some duplications were reported to have not been exact duplications, and then some duplications where there was no original, there was unable to make a comparison. Item number 59, there is a statutory obligation for a signature in the poll book to be present, certifying that the seal number is there by the Board of Canvassers, and that was not apparently done. There was some objections that we've already dealt with related to the front side of the ballot, but there is the one related to being able to look at the tabulator tape as item number 60. The tabulator tapes were present. People were asking to be able to view them, and in a lack of transparency, It was determined that they didn't have the right to see the tabulator tapes or to take pictures of it, and that was pretty much widespread and was objected to. The last thing, so in Kent County, item number 86. So,
We're 27 to 85.
oh, I'm
I-
sorry.
Mr. Hartman, I think that your numbers are not the same as mine.
I numbered
So
them.
for your clarification, for a correct record, I would urge you to renumber.
Okay,
Because the numbers that you were referencing were not the ones that I know that Jeanette and I have, but.
You referenced a no signature in the poll book for a ballot container seal. I think you said that was 49, that's actually 54.
oh,
So we just started from the beginning and
Yeah, I
just counted 1, 2,
apologize.
3.
I see I made an error when I flipped over from 44. I read that as a 49, I started 50 on the next page. My apologies.
It's a human error, it's okay.
Yep, so the,
Not a crime.
yep, 49 through, so the, item number 75, I'm sorry, item number, let me look here to be clear here. Number 84, in Genesee County, they indicated that the, yes, no did not match the tabulator. I don't know if that ballot is there, but that is a unique, item that I would ask you to address. Related to the lack of signature that I referenced earlier, that'd be item number 54. And inability to see tabulator tapes, that'd be item number 55. The duplication errors were cited throughout here, as well as the printed ballot issues were items 36 and 37. So those would be my comments related to those. If you have the ballots where the people have indicated that they have identified the ballot as a concern, I would ask that you would examine those. Thank you.
Thank you. Mr. Liedl? While he's getting situated, staff, are there items in this bucket that require, that have something for us to open?
So I think when we initially put these in this category, we believed that it was a challenge to a process or a procedure.
Right.
Are there any where the ballot would be, looking at the ballot would be part of that, Adam?
I don't believe so.
Okay.
But if there are some, I can tell you, like, if you have questions about them, I can tell you if we have the ballot, and if you want us to open it, we can open it.
Okay. Yeah, I think my understanding of this as we've set out was that it was bucket 3 where the actual determination was going to need to be made. And if we do not have something like that in this, then I don't see a need to do that. But again, I want to make sure we are following what we've laid out.
Yeah, well, so for 27, which is a blank ballot, I mean, I think the reason that we classified it as a process procedure is that there's nothing, I mean, some people do choose to put a blank ballot in, like I don't know why. I've heard that some people just like to have a record that they voted, but they don't actually want to vote for anybody or anything. So there's
least do it
nothing
right
illegal
in.
about doing that or counting that ballot, but we do have the blank ballot here if the board wants to look at the blank ballot.
Okay. Probably, I guess we will take a look at the blank ballot, make sure there's not some secret message. But Mr. Liedl, go ahead while I open this.
Sure. Thank you, Mr. Chairman, and members. I'll be brief. We've provided you a written reason why we believe each and every one of these appeals should be rejected. They've been previously reviewed and detailed at the recounts by a county board of canvassers, every one of them, and rejected, all of them, by a county board of canvassers. In addition, the challenges were appealed to your designated representative, reviewed and detailed, and rejected. We urge you to reject them as well for the reasons stated in our written response, because we believe that it is time that this frivolous, feckless and failed fishing expedition be brought to a close. Thank you.
Thank you, sir. As I've opened this, there's, again, the point of this recount was looking at items, the proposals 2 and 3.
Was it just 3?
Yes, this actually was part of only 3. However, so on the back, yes, this is blank. But, and I'm not in any way advocating that they should have had the ability to do this because it was not part of the scope. You look at this and they have voted for a straight party, and then the mayor they invalidated their vote, but they voted for the city, for mayor of Flint. So they have voted. So this isn't just a straight up blank ballot. They had a point they wanted to make. They had people they wanted to vote for. There's nothing that indicates that you have to vote for every ballot item. So there's no reason to proceed to accept this challenge. In my mind, do you even want to see this? Here's the envelope. So, sir?
Yes, I was told by the Board of Elections to come here to appeal my challenge. I was told by this gal on item 5 I would be able to speak to my challenge.
And your
Drove all the way over here from Kent County for this.
and your name is?
Dale Keith Hinkle Jr. on the blue form I filled, and also on the challenge envelope with the information inside.
And which one is your challenge?
My challenge, your numbering system, I didn't bother to match it, it's on the top of page.
Number 30? Challenger provided a picture of a ballot that did not challenge at the time of counting?
This is a procedural challenge. What is labeled on your list here is not able to view the front side of the ballot.
So, I do have your name on here. And as I mentioned previously, just before we started this item, because
You're misrepresenting so much information here that I can help address.
I'm not misrepresenting anything. I think,
This whole board, this whole room, these lawyers, folks have said things. I can help correct those if you wanted to have the.
we have public comment at the end of this meeting.
This was item 5. I was told I could come here by your staff to speak to.
I'm going to, perhaps against my better judgment, I'm going to, please sit down, turn the microphone on. You have 3 minutes. You need to specify what it is you are referring to here.
Kale Keith Hinkle Jr., K-A-Y-L-E, Keith, K-E-I-T-H, that's what I go by, that's why I say it, Hinkle, H-I-N-K-L-E-J-R. I am here, like I just said, without the microphone. I'll repeat, for the microphone. We were told that we could come here to appeal this. My own county clerk, Lisa Postumus, when we brought these procedures up there, said, these are procedural challenges. This is not the right board to look at them. His characterization that they looked at them closely is totally false. They did not look at them all. They simply said they're not going to look at them and told us that we needed to come here to do this today.
Mr. Hinkle, can you please state which one of these items you are referring to? Which is your challenge?
Can you read the challenge, please?
You guys have my copy. I can bring up a copy on my thing. It is top of page 2.
Top of
Number
page
63.
2
I don't know,
is
it says-
Varian.
Oh, I'm sorry, it's proposal 2. It's page 5. I'm sorry.
So you are either, because I'm looking at Kent County, either 63 or 64? Because there are two
Yes.
with the same?
Yes.
Okay, thank you.
Absolutely.
Sorry about the other number. I was trying to find the Kent.
All right. So the issues that are in my written statement that apparently you're not going to open and look at, which I was told you would, they originally did not document the argument that was there. They simply said it's beyond their purview. I said, well, you take into writing and put in the record to the appeal. I did not, so I had to write my own written thing there on the spot. I did that quickly, and it is here. What's included that has not been brought up yet today is we had a bag that the zipper was destroyed. Who knows what ballots were in it? was deemed uncountable. We had a precinct that was missing 30 ballots. No investigation was done. We were told similar sort of things that we're being told here today. It's outside the purview of the recount. And I don't know what details you had set up with Mr. Hartman ahead of time, but my point in there is an investigation needs to be done. We have no idea how this zipper was broke, who broke it, when, how. It's the kind of thing to refer to this stuff as accidental is insane. I agree with that assessment. And then we have a precinct that was certified that 30 ballots are missing. It doesn't come up in the Board of Canvassing at that location. It only came up because of the recount. Board of Canvassing doesn't certify that the ballots are actually in those bags and do that work. So the mischaracterization is something strong. So the point was, and this particular objection that I have here, this challenge that we did, is we also had about a third of the precincts, the bags had been opened. They had been resealed on November 18th. They were not the original seals from November 8th for a third of the precincts approximately there in Kent County. And that means we have no idea what bags, what happened where, okay? There was no cause written on there like was done when we did the recount, why they were opened and resealed. But what we do know is they were opened and resealed, and True the Vote lawyer said it was all original November 8 seals. He was incorrect. So the fact is we needed to be able to see the front of those ballots to view whether or not they were in the precincts they were being counted for. And we were not allowed to do that.
Time is up,
by
sir.
many of the folks.
Anybody on the opposing side care to address any of that? Sure.
I take it you have no questions.
Thank you, Mr. Chairman and member. I would just like to remind the board and others of the procedures that the board has adopted. Appeals have occurred. Right? Under your procedures, challenges were made at the time of the recount. They were processed and challenged. They had the opportunity to appeal to your staff, and then at that recount, the appeal could be made to this board. Your procedures do not allow for any sort of consideration of additional information. Section, let's see, 4B of the procedures that you adopted says that all challenges will be fully documented at the time the challenge is made. So this board has no authority under your own procedures to consider additional information today. Secondly, under the instructions that you sent out and the procedures that you adopted, all of these challenges have been made on behalf of an interested party. The Election Integrity Fund or Force or both, depending on which name they use. They have a representative here today. Your instructions for this meeting indicated that there would be one person allowed to speak for up to 3 minutes for each agenda item for each interested party. Now, if someone here represents a challenge not made by someone representing an interested party, the EIF, perhaps that's different. But we would encourage you to stick to your own procedures and dispose of these matters as expeditiously as possible. Thank you.
Thank you. We have wide leeway and discretion here, and I think if I'm doing my job, everybody's going to be upset with what we're doing here in some fashion. So, again, I think it's important that people have an opportunity to speak. I've laid out the public comment process, but I wanted to respect your insistence. I don't have to, but I wanted to. That being said, we've got some information before us. I believe Mr. Hauskamp has a question or a comment.
I'd just like to, Mr. Hinkle, just a quick comment on something you said while you were speaking. You said that you didn't know what, quote, deal we made with Mr. Hartman.
Yes.
But I'm going to go back to one thing we talked about way at the beginning of this. There was a narrow lane that was established procedurally process-wise, the whole 9 yards was a very narrow lane for proposal 2 and 3 to be recounted. Mr. Hartman we negotiated that here with him. And so that is exactly, I know it doesn't seem fair, but that's exactly the road that we are following here this morning, is we are living within the box that was created for this recount. And I would argue with you that, or I would say to you that if you didn't read that, what Mr. Hartman has as the rules of the recount, I would urge you to read that. That would
I'd be
help you.
happy to, and I appreciate the thought there. I just said I was not aware of
No,
that.
I know.
What
I hear
I'm
what you're
following
saying.
is the instructions.
There was no agreement. You guys made a
Well,
determination, and I abided by it.
You're mischaracterizing his
No,
version
I'm-
of it, so
well,
we'll get
no.
at that later. But my point is that my clerk said she's never had a procedural challenge at a county level. They did not look at any procedural challenges at county level. His characterization that they deeply looked at those and dealt with them, and that was where it was supposed to be dealt with, and you guys can't deal with it, is the exact opposite we were told at the county.
In my
They can't
understanding-
deal with it, and we have to come here to deal with it, was what we were told.
And
So
again,
you guys got to
Mr.
make up your
Hinkle-
mind on your procedures, which way you're going to do it.
Well,
finish my sentence, and
but there should be a
You've
rule.
reiterated it multiple times. The issue in the punt, in my understanding, it's a procedural process issue. Those are things we set when we had our previous meeting, laying out the guidelines. The locals were operating with what we laid out. Because you are challenging what we laid out, they said, come to us and talk to us. And what we're saying right now is, that's not what we agreed to. It's not within the purview.
Your people
You are
told us
ru-
to come here. Your Board of Elections guy told us to come here, not me.
We are all set with information from you. Thank you.
All right. The only thing I'll add quickly is that you're suggesting you're going to save money by railroading this thing through and rubber stamping it. All you're doing is inviting a whole ton of money into these lawyers' pockets because you're sending this to court where it's going to cost all of us a lot more money. Thank you.
If there were legitimate court proceedings, they would have happened already, and evidence would have been presented, not just wild conjecture.
Where's your impartiality, Tony? Guys, calm down. Let them proceed with the process. Quiet.
I think we've exhausted comment on this. Looking at entertaining a motion on items, I believe it would be 27 through 85. You all set with this?
Mr. Chairman, I move that the Board of State Mr. Chairman, I move that the Board of State Canvassers reject challenges number 27 through 85.
Have a motion
Second.
and support. Do we have discussion on this? Do not see any. All those in favor of the motion signify by saying aye. Aye. Any opposed? Motion carries 4-0. That would deal with items that were in the second bucket of process and procedure. We would now be on number 86 through 119, which these are ones that fall into bucket 3, where determinations have been made, and it's up to a challenge now to us to review what the determination was. Am I characterizing that correctly?
That's correct.
Thank you. If my fellow board members do not object, I was thinking of a 10-minute recess. I've had quite a bit of coffee, probably should take a break, give others a chance to take a break, and we'll be back, let's say 11:30. So in recess until 11:30.
We'll move it
Merry Christmas. Would you like to see the Christmas socks I wore?
Yeah, let's see those. Those are awesome. My favorite ones I have are with a fox, and it says 0 fox.
I could use that.
Hey, Mary Ellen, Jeanette, I'm out of here. Have a Merry Christmas.
Holiday. I've just been around, 3/4 of my staff is out. I got a text message before we started the meeting. So I'm like, nope,
I had the flu last week.
I had COVID before Thanksgiving, or actually,
So we were just talking about this. Like, I would rather, like, with the flu that I had, like, I would rather have COVID.
you know, the COVID was bad.
we have a mix, COVID and flu.
Yeah, I had the flu. My son had the flu and RSV, and my daughter
Net
had RSV.
change,
RSV is horrible.
6 towards the nose. 14 more yes votes, 20 no votes. So a net change of 6 in the direction.
right, calling this meeting back to order at 11:37. Just one addition, just reiteration of kind of where we are. We're still on agenda item number 5. What we are left with are items 86 through 119, which, based on the bucket and the issue at hand, will require us to open each envelope and look at the ballot and make a determination. So we'll do these one by one. We'll try to keep it quick. I know there are a couple of people they are the challenger. We will give them the 3 minutes that was mentioned to discuss. I'm hopeful to be out of here relatively quickly, understanding that with 30 some of these, it'll take a little bit of time. So with that, we are on challenge number 86. It is Marquette County, and I got a fancy little tool here, and that the challenge is that the ballot is crumpled. Ballot is crumpled and torn and looks different than other ballots. Ballot should not be counted. The County Board of Canvassers affirmed the action of the recount team, which was to count the ballot. The ruling by the representative of Board of State Canvassers was a firm recount team. And so the challenge would be asking us to not count the ballot. As I open and look at this, I see that proposal 3 circle, it is fully filled in as a yes vote. It is a little bit crumpled, but it says official ballot. I see no reason to dismiss this ballot. Any discussion on that?
It looks fine to me, and obviously the ballot was readable by the tabulators, so I think we have no reason to reject it.
Okay.
Same.
I have a dog who sometimes receives my mail, so I understand how things can be a little bit crumpled or possibly chewed on.
And obviously, it went through the tabulator to be tabulated. I don't see any need to reject it.
Okay, so then we would be in position to accept a motion on challenge number 86.
I move that the Board of State Canvassers reject the challenge on item number 86.
I second the motion.
Motion and support. Any discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Any opposed? Motion carries 4-0.
And I was not opposed, I was an aye.
I heard you. I figured.
I just want it.
Maybe start paying attention, Jeanette.
It's really hard sometimes.
We are on challenge number 87. This is Genesee County, Grand Blanc Township. Ballot is invalid because of overvote. Entire ballot is invalid because of the overvote. And open this, what we have here on proposal 22-3. They filled in both the yes and the no. It is in blue ink. It's consistent with the ink they've been using, and then on this proposal, they have X'd out the no which would make this a yes, would be likely, I think, Director Brader or Adam, that the machine would just count this as an overvote, but in the recount process, because human error was involved and human eyes were laid on this, it was clear that they viewed this as somebody accidentally marked no, crossed it out, and marked yes. The ruling by the County Board of Canvassers and the representative is to reject this challenge. In my mind, I would affirm that and therefore reject. But fellow members, if you would like to take a look at this.
These are our comparisons. May I ask Director Brader a question?
Please do.
Director Brader, in the guidelines you provided for valid corrections, you show an X through the box, but you, in addition to that, show a call-out with the word mistake written in there. Are both of those required to make it a legitimate correction, or is it one or the other?
So either one of those would be an example in which the voter corrected their marking, crossed it out. And so either one of those would be a situation in which, according to the validity standards, the vote would be counted for the oval or the square that's filled in and not for the one that was X'd out.
So a simple check through, a simple X through is a valid correction?
Yes.
And if, as I'm reading this, the challenge is that the entire ballot is invalid because of the overvote. It's not even simply related to proposal 22-3. It's that they are saying the entire ballot should be tossed. That's how I read it. So am I correct in reading it that way?
I'm not sure what the intent is. What's the exact wording?
The exact wording is entire ballot is invalid because of the overvote.
Right, so that appears to be the claim. So in that case, I mean, there'd be two separate issues. One would be whether the ballot, whether the vote for that question can be counted based on the voter's correction. And then the other question would be, even if it weren't, if that were determined to be overvoted, would all the other races on the ballot have to be invalidated? And the answer to that would be no.
Thank you. So that would, even in my mind, further strengthen a rejection because, just because there's a mistake on one portion of the ballot in one race or one proposal does not in any way invalidate the entire ballot and therefore the entirety of that person's participation in the process.
I agree. No, I don't have a question.
Okay. Mr. Hartman?
I see three quick issues. The first issue is that a valid mark, despite the Secretary of State guidance, is governed by 168.803, and therefore it is in fact an overvote. Number two is MCL 168.795, parent 2, clearly indicates that the machine is to be programmed to reject an overvote. When the machine is programmed to reject an overvote, if it is an in-person ballot, which I'm not clear, the voter has the opportunity to spoil the ballot, fix the ballot, and resubmit it. If it is an absentee vote, the statute indicates very clearly that it is to be rejected, the ballot. This is in compliance with HAVA, Section 301, which indicates that there is a requirement that the machines be programmed to reject to give the voter an opportunity to correct an overvote or a blank ballot. I would also point out that they address the absentee votes to make sure that people are not disenfranchised with a three-part plan. One part is to make sure there's voter education, Number 2 is instructions. And number 3 is the procedure and the training of the clerk staff. That is all part of the definition of a voting system. And therefore, I believe it is properly stated that the ballot should have been, not only should it not count for Proposal 3 because it violates the definition of a mark, but the ballot should have been rejected by the machines, but the machines are not programmed correctly, either the adjudicator or the tabulator. And lastly, it is a process in which I believe we are not compliant with federal and state law. Thank you.
If Mr. Hartman would like to see changes in how the election law is administered, he may be close to the right building, but he's in the wrong room and in front of the wrong body. The 102nd Michigan Legislature convenes on the second Wednesday in January, and he's free, as is his constitutional right, to petition the legislature for changes in the election law. Thank you.
Thank you.
Mr. Chair, may I ask a question of Director Brader?
You sure can.
Okay. Director Brader, when we went through the process of getting new voting machines, I remember distinctly asking questions. They basically, that process going through the mock election, if a voter overvotes, the tabulator will let them know that they overvoted and rejected. But is it possible for a voter to override and have it accepted, but that one certain race is not accepted? Is that a correct statement, or?
That's correct. The tabulator is programmed to reject. For an in-person voter, the voter then gets the choice of whether they want to spoil that ballot and start a new one, or if they want to just put it through and have that vote for that office not counted, they can do that. When it comes to absentee voters, that's governed by a separate section, which is 798C. And that indication, because the voter's not there, the individual is tabulating the absentee ballot. In that instance, it says a vote for each elective office or ballot question in which an error is confirmed shall not be counted. It doesn't say the entire ballot shall not be counted.
Director Brader, I've got a question for you. And I'm referencing the documents that we were provided for guidelines. And I already asked you about the X mark, and you said that's valid, but on the next page of that, there's examples of called false read situations requiring duplication of the ballot. And when I look at the diagrams and I look at the false overvote ballot correction, was that ballot that we just looked at something that would have required a duplicate?
If it were to be put through the tabulator, yes.
Could I put a question to Ms.?
Yep.
Yeah. Mr. Brader, isn't there also the adjudication process, which does not require duplication of the ballot, but which allows the identification of the overvote and then the count of all of the races which are not overvoted?
Yes, that's correct.
But I think that it does it in the adjudication process where there's a correction, then that process allows to take account of the correction, does it not?
Yes.
Okay.
So we don't know if one was created or not.
And it's because he mentioned about the duplicate because, or if it went through a tabulator, but it was correct, it was folded as though it was an absentee, correct? That ballot? And again,
Yeah, and it's for an absent voter counting board, so definitely absentee ballot.
and again, the issue at hand is the invalidation of the entire ballot because of this. So my position remains unchanged, that I think this challenge should be rejected.
Mr. Chairman, I would also note that this argument with regard to rejection of entire ballots where there is a single overvote is one that Mr. Hartman made in a lawsuit prior to the election, and that argument was quite appropriately rejected by Judge Timothy Kenny in Wayne Circuit Court, as were many of the other arguments which Mr. Hartman makes to this board as justification for engaging in this frivolous recount.
Other questions?
No.
I would entertain a motion.
Mr. Chair, I move that the Board of State Canvassers reject challenge number 87.
Second.
We have motion and support. Any discussion? All those in favor of the motion signify by saying aye. Aye. Any opposed? Motion carries 4-0. Moving on, challenge number 88. This is Marquette County, what it looks like City of Marquette. Absent voter board 7. Same issue. Ballot is invalid because of overvote. It says invalid write-in on races other than Prop 3 may distinguish ballot. County Board of Canvassers affirm the count team. Representative of us, affirm count team. Ballot is not identifiable. So, again, they are saying invalid write-in on races other than Prop 3.
Yeah, that's something different. And
The recount only pertained, in this case, to Prop 3.
Right. So essentially, as I understand what is in front of us, on this, the person very clearly voted yes for Proposal 3, but on the side of the ballot that the recount people would be looking at, they have a couple of write-ins, not actual candidates, Snoopy, Rerun, and Homer Simpson. So they didn't want to vote for the individuals in a couple of these slots. So they did what many of us probably have done, express your distaste for the other candidates by writing something else. And this challenge is saying because of that, we should reject their ballot and therefore their vote on Prop 3. I cannot stress the absurdity of that challenge, or my belief in the absurdity of that challenge. Would anybody like to take a look at this? Thanks.
Chairman Daunt, 803(1)A is very explicit. It states that if a ballot has been marked in a way to distinguish it, such as using Mickey Mouse or Donald Duck or Snoop Dogg or whatever you wish to put in there, that it is an appropriate challenge, and the statute says the ballot would be void. The question is whether or not this was made as a distinguishing mark. I would ask you to review the statute. The statute prescribes the ballot is void. 803.
Mr. Hartman, these are not, this is not defacing a ballot. These entries here are legitimate write-in names, whether they're,
You have to be registered with
Sir?
the county. You have to be registered with the county for write-ins.
Sir, that is incorrect. You can write whatever you want. It just will not be counted. Anything else, Mr. Hartman?
So let me just read the exact language, and that way there's no confusion.
Will this take 90 seconds or less?
Yes. This is for counting and recounting of votes is the caption. 1, except otherwise provided in this act, the following rules govern the counting and recounting of votes. A, if it is clearly evident from examination of ballot that the ballot has been mutilated for the purpose of distinguishing it, or there has been placed upon the ballot some mark, printing, or writing for the purpose of distinguishing it, the ballot is void and should not be counted. It says the ballot should be void. So the question is whether or not the person was marking the ballot to distinguish it by using people that are not registered. You have to be registered as a write-in. There's a list that's provided, and if you're using a name off of that list, such as Mickey Mouse or Donald Duck, you may be distinguishing your ballot. That's a factual determination that you would make. But if you do decide it's a distinguishing mark, then the remedy is voiding the ballot. Thank you.
Tim? Any questions? Okay, I believe motion would be in order.
let me move on this one. I move that number 88, Marquette AV7, for the reason that the ballot is invalid because of overvote, I would reject that.
Second.
Motion and support. Any discussion? All those in favor signify by saying aye. Aye. Any opposed? Motion carries 4-0. We are now on Challenge 89, Muskegon County in Fruitport.
Can we have your stickies?
Yeah, sure can.
It's like broken stickies.
This is ballot should not count because of bleed through of marker and use of marker. So they're seeking to have this ballot tossed because of the use of marker. The county Board of Canvassers and our representative at the process indicated that the ballot should count, therefore that they rejected this challenge. This is very similar to something earlier in the morning where they've used a Sharpie, it's bled through on the other side. It does not impact the markings for Proposal 22-3. It is a clear yes vote. Again, pretty simple determination in my mind that we should reject this challenge.
Mr. Chairman, the challenge seems to suggest that we should reject it because they used a marker, which is an additional reason to reject it.
Yes.
In 60 seconds, Chairman Daunt, 736D requires use of a blue or black ink pen. That's what the statute requires.
Motion would be in order on number 89.
Mr. Chairman, I move that the Board of Canvassers reject challenge number 89.
Motion and support. Any discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Any
Aye.
opposed? Any opposed? Motion carries 4-0. That moves us to challenge number 90. Mr. Hartman indicated that Philip O'Halloran is the individual that had made the challenge on these, I'm just making sure I got this right. So 90 to 98, he would speak on. These are distinguishing marks should not be counted, similar to other, so this is back to what we just previously talked about with Snoopy and Homer. We will address each of these one by one, but Mr. O'Halloran,
We could probably address them as one.
yeah. So why don't you, I'll give you 3 minutes. If you can not use all of it, that would be great. Please state and spell your name. And
Philip, first name, last name is Halloran.
And Mr. O'Halloran, you are not an attorney?
No.
Okay, and our practice is if you are not an attorney and you are testifying on these types of issues outside of public comment, that we have you raise your hand and swear, tell the truth. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Floor is yours.
Okay, I was a challenger in Genesee County, and this was on the 16th of December. We were at a table where we challenged 8 or 9 ballots, I believe it was 9 ballots, and they had pinkish reddish marks on the opposite side of the ballot, and these were several of these, and they seemed to be from the same precinct, these pink reddish marks. So I'll show you, I just made a little kind of a mock-up. I don't have a ballot, I wish I did, but you had your mark that presumably the voter was putting in, which is going to be right here in black or blue ink, okay? On the back of the ballot was red ink, the exact same spot at the back of the ballot. So as challengers, we focus on deviations from the norms in a secure election that might indicate errors or fraud. So the reason that this is a concern is there is one particular fraud hypothesis that could explain that, namely that these ballots, which appeared randomly during the recount process, had possibly been laid on a surface containing a small amount of partially dried red ink or other type of red pigment. So if a nefarious actor had pressed on the ballot where the bubble was indicating that the person's trying to vote for somebody, if they put the pressure on it, some of that red ink on the underlying surface could have imprinted lightly onto the back of that ballot, thereby creating the marks that we saw. And you can look at those red marks there. They should be in your possession. Because that's the pattern that we saw with the red ink directly opposite where the vote marks were in blue or black ink. They essentially ruled out bleed through because it can't bleed through, a blue ink or black ink cannot bleed through red ink on the other side as far as I'm aware. There's no proof that anything nefarious occurred, but it's strange that numerous ballots, presumably coming from many different voters, all seem to be linked by these same red marks. We challenged several of these ballots with the red markings. The 4 Genesee County canvassers and 1 State Bureau of Elections representative all reflexively and very swiftly dismissed the red smudges as bleed through, quote, bleed through, end quote. I asked the Secretary of State rep from the Bureau of Elections, Lori Bourbonnais, how does blue ink bleed through to the other side as red? She had no answer, and all 5 officials dismissed our concerns. There was no discussion or even speculation or questioning as to how this anomaly might have occurred. So my concern is that there should have been an investigation. That same body, that same County Board of Canvassers did refer to the prosecutor another instance that same day, and it had to do with with missing ballots, like 50, I believe it was 50 missing ballots. I have to check on that to be sure. And so I'd like to know why a full investigation didn't occur. One of the investigations that I suggested at the time would be that we could look at the rest of the ballots that were present in that room. There were, thousands of them actually, and to see if they had the similar red marks, because this was restricted to just one precinct, Precinct 6 in Fenton. As far, I believe it may have been a walk-in precinct, but one of the ballots had a fold in it, which could indicate it was an absent voter ballot. At any rate, whether it was a walk-in or a AV ballot these were occurring with, it should be investigated to confirm that it's just an innocent smudge of some sort.
So, investigation's not our purview. I will say, these look like they're all from the same place. Any number of things that could be at issue here. One thing I think is important to point out, the first two I opened on proposal 22-3, the first one was a no vote, the second was a yes vote. You're a really terrible fraudster if you're just alternating your votes.
Well, the thing is, the vote would have occurred on the other side. In other words, the person who was marking that would have been involved or trying to vote for another race. So the bleed through in the red side, if that came in on, proposal 2 or 3, it still would have been the individual marking for another race.
The way that it looks, though, it looks like someone had a ballpoint pen, and it looks like when they voted on proposal 3, it looks like they very clearly were writing inside that circle, and that the indentation passed through that paper. And,
Right,
and the mark on that paper is, I don't know where the pink came from.
Well, that's the question is, where did the pink come from, and did the pink connect all those disparate ballots from the same precinct? And if so, does that indicate any kind of nefarious activity, which could, if it was true, then all of those ballots in their entirety, each race on every one of those ballots would be void. And that's why we're bringing this up. And that's why I was concerned that an investigation should have been authorized right then and there. That's why we brought it up to the board. I appealed it to Lori Bourbonnais and said, I'd like to bring this up to the board. And she allowed that.
I've only opened 2.
When I say the board, I mean the state board, your body.
Mr. Chair,
Yes,
my question's to Director Rader. Is that okay?
yes, please.
Thank you. But Director Rader, who is responsible for printing ballots?
For printing the blank ballots?
Yes.
That would be done by the counties.
So all of Genesee blank ballots are printed through the county clerk?
Correct. The county clerk arranges with the county board to have a vendor print the ballots.
Does the county does they use one vendor, or? I guess what I'm asking is,
Yes.
can you go over the process of how these are printed?
Well, there's 4 or 5 print vendors that print ballots in the state. I believe every county uses the same vendor to print all of the county's ballots. Don't know if I remember offhand which vendor Genesee County used, but it would have been likely the same one that printed all the county's ballots. Possibly Printing Systems Incorporated.
Yeah. Mr. Chair, I note that on number 91, it appears that the ballots, the votes were marked initially with a red pen and then written over with black. So the bleed-through that is evident is in fact the red bleed-through is from the vote on the other side. So I don't know about the other ballots. I'm only looking at this one. And the red mark on the other side.
That would be more indication that the person, that a nefarious actor may be at play here because of the fact that.
I'm sorry, it may be indicative of what?
I'm sorry, oh, there we go, sorry. Yeah, so that would be more indication that there is potentially a nefarious actor if you're seeing a red mark red pen being used on one of them, then it's possible that that same red pen could have bled through on the other, from the other ones, especially if one person is doing all of these red marked ballots, then that would be definition of fraud. So what I'm saying is that you're mentioning that there is a red pen on one of the filled-in bubbles, right?
I want to reiterate for the numerous time, this investigatory request is not within our purview. We are here to look at challenges, regardless of how silly they may seem. There is a process. The individuals have participated in the process. We have a challenge before us. The request is that we invalidate the ballot because of a distinguishing mark, the red bleed through, whatever may have caused it. There was a red folder on the table and somebody filled it in, and so it bled. Whatever the case may be, in my mind, the request that we invalidate the ballot because of this should be rejected swiftly. And so
My request would be that there would be an investigation. Does your body have authority to
we are not
investigate?
an investigatory body.
So you do not have authority to investigate?
We are not an investigatory body. We are here to review these challenges and then to certify the results of the recount.
Because
Again,
I've
if
got 168872
Sir,
that.
let me finish.
Okay, go ahead. Sorry.
If people have reason to believe that a crime has been committed, there are appropriate channels to take, and that involves forwarding the concern with evidence to the local law enforcement officials. We cannot just make willy-nilly accusations in this country and hope somebody will pick it up and conduct a fishing expedition. That is a recipe for disaster. We have the rule of law in this country to avoid that, so that you are not determined, your justice is not determined upon who is in control and whether or not they agree with you.
Mr. Chair, I'm sorry, I don't mean to interrupt you. I know that I would like to see the rest of these.
Okay?
Is that okay if we open them, or
I
can
only
you please?
avoided opening multiple so we didn't get confused.
No, I know.
Let's,
We will keep them with them. I just would like to see, I mean, it looks to where those marks are. I mean, black ink is not just, I mean, to get the color black, you have to use other colors. And it looks where those are kind of scribbled around matches the pattern of where the person had marked their vote. And when you flip it over, even the impression is the same of where those marks are. And so I just want to make sure that we open every single one, that we just want to make sure we don't mess them up. But the intent of the voter is there, and I understand you have.
We're not concerned about the intent of the voter, it's more the eligibility of the voter, and if the voter is eligible versus a person who
That's
is
not
committing
about
fraud.
the recount was to look at, on this one, Proposal 3, and there are votes for Proposal 3.
But the
And that's
recount
what
would
the
be,
recount board had to look at.
but the recount would change, the count would change if it was determined by investigatory bodies that the ballots were fraudulent and not eligible. That would change the recount. It would subtract 9 votes. And then that says nothing to the fact that there might be others like it in that same jurisdiction.
Sir, can I just, it's just completely outside of this, of where you went with that, but this is more than just I know that you're doing a recount. Part of what we look at up here too is, this represents a Michigan citizen. And so do these. These represent people who got up on the morning of Election Day, and they went to their poll, and they voted, and they have a vote, and they had a right to vote. And to invalidate some, and by the way, there's some of these that are marked yes for proposal 3, and there's some that are marked no.
With all due respect, I didn't suggest that we invalidate them. I suggested that we investigate these ballots and other ballots in that jurisdiction because of the, the possibility that there could be something nefarious going on. We also are in this, it was in the same jurisdiction where 50 ballots were unaccounted for, just poof, missing. And they did refer those to the prosecutor at our insistence, and they complied. The Board of Canvassers complied with our requests. And so would it be that, it'd be that unreasonable for us to ask that your body or anybody would add this series of anomalies to the investigation of the prosecutors? Would that be out of line, or am I being presumptuous? And it may be completely innocent. In fact, I'd say it might even be likely that it's completely innocent. But I think the voters deserve to have the board do their duty. And I'm reading here 168.872. It says if there is probably cause to believe that there has been fraud, and again, that's arguable, either way, debatable, wrongdoing or a violation of the law in respect to the said election for which said recount has been petitioned, the said canvassers shall make full and complete investigation of the same. Said canvassers shall have full power and authority to subpoena witnesses and to open any ballot box, regardless of the condition in which same may be found, and may break open, if sealed, the seal thereon and examine the ballots contained therein. If after the investigation said board has good reason to believe any fraud, wrongdoing, or violation of law has been committed in respect to the said election, then the said Board of Canvassers shall forthwith make a written report of their findings to the prosecuting attorney and to the circuit judge or judges of the county where the petitioner resides, if it be county township. Then later it mentions, let's see here, I want to say it mentions law enforcement, but I think I've said enough on that. You can read the entire section.
You said at some point about, it may be completely innocent, let's figure that out. We do not ask people to prove their innocence in this country. We ask the government to prove guilt.
How can we do that without an investigation?
I am tired of this line of argument. If you have proof, take it to the law enforcement. We are not, sir, I will have you removed.
Mr. Dodd, I will go to jail if they want to arrest me. The law enforcement does not listen to us because the Attorney General's office is intimidating law enforcement.
10 seconds.
That is
One more outburst, I will have you removed. Sick of the argument.
But we
You're
have
done.
probable
You're done. We're done. Thank you.
Thank you very much.
Mr. Lidl?
A couple quick items. I happen to have been lead attorney for the PTV 2022 and RFFA coalition, and I was president in Genesee County and did observe a number of these ballots myself. Procedurally, first I'd urge you to consider these as a whole, as you review them. The issue is the same, the marks appear to be the same issue, and in the interest of time, you could dispose of these as was done by both the County Board of Canvassers and your representative in Genesee County that day. Secondly, I'd remind you that under your procedures, you may only consider as part of a challenge the information that is submitted in the signed challenge, not any extraneous material submitted today. And then lastly, with regard to the substance of this claim, if I understand correctly, the official color of the Chinese Communist Party is red, right? One could speculate that an agent of Red China transported himself or herself to Fenton Township and marked the ballot. One could speculate that that agent of Red China did so in a nefarious manner, but that is nothing more than rank speculation that is not a matter for this board. Even under the statute that the proponents of this recount misrepresent, there must be one probable cause that either fraud, wrongdoing, or a violation of the law occurred, right? any sort of fraud or violation of the law with criminal intent requires criminal intent. We have no evidence. We have simply rank speculation that is not under the election law a matter that this board should spend any time on. None. Thank you.
So I've opened all of these 90 through 98. They appear to all be very similar. The votes are some yes, some no. Same kind of marking in terms of some kind of bleed through. Say it again, shouldn't invalidate the ballot. Motion would be in order once my fellow board members are done reviewing the information or the items at hand. And I would agree with Mr. Lidl that because these are all the same, that we can take care of them in bulk for purposes of that motion.
Point of information? I just have a question.
Okay.
If everything's fine on these ballots, then why don't they all bleed through like that? If it's not something different about that paper or something different about what's going on there, why is it?
Why is it sunny in Flint and raining in Port Huron? I don't know.
No,
It's not for us to determine.
you could, those ballots could have been rubbed when the person picked them up before, when they were blank. Those are not, those marks, by the way, I would add to the fact that what you're looking at with those little pink marks, those don't deface that ballot in any way, shape, or form that any common sense would. No one is obviously using those pink marks to change the way a ballot came out. Those pink marks are in, white spaces. I'm not sure what the significance of those would be.
Mr. Chair, I move that the Board of State Canvassers, whoops. I got you. Yeah, I move that the Board of State Canvassers reject challenges number 90 through 98.
I'll second the motion.
Motion and support. Any discussion? All those in favor of the motion signify by saying aye. Aye.
Aye.
Any opposed? Motion carries 4-0. Number 99, challenge number 99, Wayne County, City of Detroit, absentee voter counting board 72. This says, reason for challenge, do not see as a correction.
I think the intent there is the challenger didn't believe that what was treated as a correction was actually a correction.
Okay, thank you. So we have proposal 3. There is they filled in both ovals, yes and no. They put an X next to the no, which would mean it was then counted as a yes vote. This challenger is saying that's not a proper correction. The ruling by the County Board of Canvassers is, it says accepting. Ruling by the representative of Board of State Canvassers is agree. I would be, I'm confused as to when they're saying accepting, they're accepting it as a proper vote, or they're accepting the challenge?
The recount please, Adam, correct me if I'm wrong, but I believe the recount assistant and then the board and the bureau representative determined that the correction was accepted as a correction, meaning that the ballot was accepted as voted for the race, for the questioning.
That's what I thought. There was a lot of odd wording I wanted to confirm. So then before us is, do we, upon looking at this and the procedures and process that was laid out, do we agree that it is a proper correction based on what we have looked at previously, I would say it does qualify, sorry about that, as a proper correction.
No, it actually does not. Is that X outside the box?
But the oval is filled in now.
No. Yeah.
So we have,
That's an invalid marking.
so what we have here,
Member Housekamp, the oval is actually filled in, and those that the ovals are not filled in. 'Cause that's what my thought was, too, but
I think what he is saying, and where I have a question actually, would be both yes and no are filled in. The X is not on the oval, it's next to the no. And looking at what's provided here, this is not given a specific example. Where,
I don't have that example.
Chairman Don, if I might be so bold, the X could either indicate that they were trying to cancel the no or that they were marking the no, because when you look at the definition of a valid mark under 803, an X or a check mark can constitute a vote. Under the Bush versus Core debacle of 2000, if you recall, after that, HAVA passed a rule that said a mark has to be clearly defined, and we're not supposed to get into a question of a hanging chat or dimple chat or unequivocally applying it. In this case, because it is ambiguous, we cannot discern the voter's intent, and there should be no vote.
go ahead, Mr. Brewer.
Thank you, Mr. Chairman. The only reason I approach is that I was the lawyer for the coalition in Wayne County, and so I addressed this. I think I recall this ballot. And I think it's very clear that the voter is indicating that he was correcting his ballot and saying that no vote was a mistake. And that was the unanimous ruling of the Wayne County Board of Canvassers, sustained by your staffer on site. So I think that is a proper correction, and that voter should not be disenfranchised for that reason.
I understand your point, obviously, and in looking at, this is where I don't want to say struggling, but you look at the examples that we're looking at and that were provided as what to use as guidelines for this recount. There isn't any example where they've put the X next to a vote or a candidate or a yes or a no. They're all, the oval's filled in and they X'd through the other accidental. So, I mean, ultimately, we're being asked to make a judgment call here. In my mind, at least initially, the fact that the county board unanimously agreed that this should count holds weight because they were there, they were part of the discussion of the recount team. I think Mr. Hartman has a point as well about, assuming whether this X was meant to, like, say, no, I didn't want this one, or look here, this is the one. So,
I know, that's the problem I've got too.
Mr. Chairman, may I make a couple additional points?
Yep.
If I may. First, the Bureau has developed and used for many years a great set of examples, and that's exactly what they are. They're not an exhaustive list of the possibilities. And the other thing I really emphasize here is that I think the default should be in favor of the voter, because otherwise the voter is going to be disenfranchised. Our Constitution compels that, the statutes compel that, that if there's any doubt, the default should be in favor of the voter. Thank you, Mr. Chairman.
yep. What is your name? Signature of challenge. It looks like it says Zach something.
Mr. Chairman, we've already had one speaker to this challenge. Again, I'd urge the board to stick to its procedures.
Yeah.
The attorney has addressed it.
Mr. Chairman, I agree with you that the fact that the County Board of Canvassers unanimously concluded that that was a valid correction is something that we should give significant weight to. And that conclusion was one that was agreed to by the Bureau of Election staffer who was there. So I think, and I also agree that we should recognize that we do need to conclude that where the voter has cast a vote, that we should we should assume that the voter has correctly done it, unless it's clearly to the contrary.
Valid points.
Chairman Daunt, 871A indicates that this is a de novo review. The precedent of the board has no weight upon this determination that you must make. The case of Bush versus Gore from 2000 states it's a denial of equal protection to discern a voter's intent when it's not clear, because you are substituting your judgment for that of a voter. To count this vote, which is ambiguously marked, it is not clearly a correction, would be a violation of equal protection.
And I think as this board, we've in the past had multiple instances where there's difference of interpretation of what's before us. We've gone to court here and there a few times, and the courts have settled these things. I think we need to make a decision, and then it's on the parties involved to take it to court if they see reason to do so.
You know, on this one, I'm really confused. The no vote, there's a yes vote and a no vote on Prop 3. They've both been marked. The yes vote has been marked in very heavily. The no vote has been marked in with less pressure. And the X is by the no vote. So my question is how was this counted? Was this counted as a yes or a no? In the count that we're talking about here, was this regarded as a yes vote for Prop 3 or a no vote for Prop 3?
Could we review the ballot in the envelope just to make sure?
I believe that what we are doing here is determining the intent of the voter. And as Mr. Brewer said, these are examples where the intent of the voter, according to the person who created the examples, is made clear. But that does not mean that we cannot look at something other than the examples given to us. We look at the ballot. What do we think that the voter was indicating here?
Just to clarify, it was counted as a yes by the vote for yes by the recount assistants and the board.
And while this might be de novo review, that does not mean that we don't give respect to 4 other canvassers in Wayne County who looked at this already.
So I believe, did you have other questions or? I believe a motion at this point would be in order on challenge 99.
You know where I'm going with this. You just know where I'm going with it. I would make a motion that in.
Mike.
Mr. Chairman, I'd make a motion that in, you said the number on this is 99?
Correct.
I would make a motion that in the case of 99, that we accept this challenge. Is that the right wording?
That is the correct wording if your intention is to accept the challenge and reverse the decision of previous determinants.
And I'm only making that because I truly, when I look at that, I get that they counted it as one way, but I truly can't tell.
We have a motion. Is there support for the motion? It would appear that the motion dies for lack of support, but I will say I understand exactly where you're coming from, and ultimately come down on the side of that others have looked at this where they were closer to the process, and we are seeking to err on the side of the voter, not to mention the correction, though not exact to the examples we have, is quite similar to ones that we have seen. And if the challengers would like to pursue that in court for further clarification, invite them to do that, as is their constitutional right. So, if that motion does not proceed, would entertain a different motion.
Mr. Chair, I move that the Board of State Canvassers reject the challenge number 99.
Okay, we have motion. Is there support?
I'll support.
Motion and support. Any discussion? All right. All those in favor of the motion signify by saying aye. Aye. Those opposed?
I would have to vote nay on that.
Motion carries 3-1. Challenge number 100. We can.
I'm just asking. After this one?
Again, challenge 100, Wayne County, City of Detroit, absent voter, County Board 51. This is initials on ballot. I'm going to open this up. Braden Giacobazzi is the individual speaking on behalf of this challenge. What we have here is proposal 22-3. Both ovals are filled in. The yes is much more heavily filled in. The no is slightly filled in, but they've kind of crossed out the no, which would indicate they're Xing it out. And next to it are initials, MLE. Those initials do not appear anywhere else on this ballot. Mr. Giacobazzi, please, if you would, you're not an attorney. If you could state and spell your name, and then I will administer an oath, and then you'll have 3 minutes to state your case here.
Braden Giacobazzi. And what else was it? Sorry.
Spell your name.
Braden Giacobazzi.
Did you get that?
Was this the one where there's initials next to an oval, or where somebody appears to have filled out their whole name?
It is initials.
Okay.
And if I'm going to administer, you're not an attorney, correct?
Nope.
If you could raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, floor is yours for 3 minutes.
So clearly there are initials on that ballot, which makes it a distinguishing mark, and it ties back to a voter, which is also illegal. And there's no reason why, I mean, the law is very clear on this, and regardless of how we feel about, this person's vote, the law is very clear about how this should be treated. 8031A, the law, 168.8031A.
Any questions for Braden? No. Mr. Brewer, come on up.
Thank you, Mr. Chairman. A couple of points. First is, as we all know, it's very common when people make corrections, they put their initials by them. So that's a very common thing that we see, and I've seen it on ballots before. And frankly, a couple of initials is no way. There's no way you're going to be able to identify that ballot. That voter has not given away her or his identity by the fact of those initials. So again, I think the unanimous Wayne County Board of Canvassers and your representative at Wayne County made the correct decision and properly counted this ballot.
Yes.
Mr. Chairman, I would move that. Mr. Chairman, I would move that number 100, Wayne, Detroit, be rejected.
So motion to reject challenge number 100.
Yes.
Okay.
Support.
We have support. Discussion?
Point of information on this, I had thought this was a different challenge when I was coming up. I remember this challenge, but there's another challenge in which somebody appears to have written their entire name on a ballot and perhaps an address, but I don't even see that in here, and we seem to be missing some challenges.
We're dealing with what's been presented to us, and so if that comes up, if I open something, and there's a name on it, I'll let you know.
Well, I mean, is this the only one we're missing, or are we missing others as well? We're missing several.
There's certain process for how challenges come before us, and so it would be incumbent on the individual making the challenge to have followed the process appropriately to
We
get
did.
to this point. So
Yeah, we appealed it at Wayne County. That was me. I definitely appealed it, so. So what happens to those challenges? Like, what can we do about the ones that are not here? That
we
should
are
be?
in the process of handling a motion. So if this challenge that you are concerned about comes before us in this stack, I will give you a chance to speak.
And if it doesn't?
Then the challenge was not properly presented and appealed through.
Not properly presented by you guys, not us.
There is a
I will note that.
Thank you. It's noted. We have a motion. Was there discussion on that motion to reject challenge 100? All those in favor of the motion signify by saying aye.
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 Any opposed? Motion carries 4-0. We have, I think, 19 or 20 more of these to go. They seem to be taking about 3 to 5 minutes apiece. It's 12:43. I believe it would be wise to give folks an opportunity to take a break, maybe grab something to eat. Why don't we shoot for a recess until, does 1:30 seem appropriate to staff?
Works.
Nobody's saying no. So I'm going to recess this meeting until 1:30 PM. All right, welcome back. Call this meeting back to order at 1:39 PM. We are on challenge number 101, Marquette County, City of Marquette. Oval not completely filled in and blue tape on front of ballot. And open it up. Excuse me. Says pretty much, it says that same thing on here. The Board of Canvassers, County Board of Canvassers and our representative both affirmed the recount team decision of allowing the ballot to count. Bless you. This says, so here's the blue tape, and there are some markings. Proposal 22-3, there is a like kind of check, half fill in, but it is not fully filled in, but basing off of what we've been looking at, it's clear what this individual was, what their intent was. It matches, their marking matches each of their other on this side of the ballot. So, question is, I'll hand this to everybody to take a look so they see what I'm looking at. Does it match with past practice and what we've been doing today? Team members?
Mr. Don, Chairman Don, would you address the blue tape and what its purpose is on the front of the ballot? I understand that was unique and was the only ballot marked that way in the process.
I didn't put the blue tape there, so I wouldn't know why it's there.
Can you see whether it is covering up a challenge tape? Because I believe the Secretary of State procedure is white tape would cover up a marked number if a ballot was challenged by the precinct delegates, I'm sorry, the precinct challenge at the time of the vote being cast. Because otherwise it might be a distinguishing mark under 803(1)A as well.
Hello, Mr. Brewer. Turn your microphone on.
Thank you. I've not seen this ballot, but I would, from an informed speculation, believe that that is what that they marked it as a challenge ballot, and you hide that to protect the secrecy of the ballot. There's no requirement that it be a particular color of tape.
Our friend, Mr. Gallant.
Looks like it's been muted, so go ahead.
Thank you, Mr. Don. There's no requirement that it be a particular type of tape. The purpose of the tape is to preserve the secrecy of the ballot, and if a challenge is later brought to court, the ballot can be retrieved. That's the sole purpose. That tape was not placed on there by a voter. It's not a distinguishing mark. And this challenge, like every challenge you've heard this morning and this afternoon, should be rejected. Thank you.
Any questions, discussion on among the board? Mr. Brader, that what Mr. Brewer said, it fits with your understanding of the practice and the procedure?
Yeah, I mean, I expect this is a challenge ballot that's covered with tape, but I can't say that for sure.
Why can't we explore that by removing the tape and looking to see if it is a challenged ballot and what the ballot number is? Chairman Don, I would request that you confirm that that is a challenged ballot and identify the ballot number. A person who has filed a challenge of a ballot saying a person's not eligible to vote, that is likely a precinct ballot, not a absentee ballot. That means somebody has filed a good faith basis that that person was not eligible to vote in the election. And that is a proper inquiry of a board of canvassers to determine whether or not the voter is qualified to vote in the election. And I would cite as precedent the letter from the Attorney General from 2013, Bill Schuette, to the Detroit Board of Canvassers.
So I would just note that should definitely consult with the Attorney General's office before even considering touching the tape on that ballot. The ballot number is to be used, when there's a challenge ballot that is cast, the number is covered for the protection, for the secrecy of the ballot for the voter, so that it can't be tied back to that voter. If there is something like a court proceeding where that it is necessary to determine whether that ballot does need to be removed from the total, then a court could handle that, you know, as under the court's discretion about managing the secrecy of the voter. And we're not in that environment right now, so I would advise not to remove that tape, but pending whatever the Attorney General's office says.
So as a point of
Thank you.
information, there's no process by which a challenged ballot, when somebody says, like EIF did with people who had national change of address issues, files it before the election, the electors are not removed, absentee ballots come in or in-person ballots come in, and somebody manages to actually get a challenge on a ballot, it's never reviewed even through the recount process.
So as this ballot indicates, ballots are challenged frequently. When that ballot is challenged, it is tabulated, but it can be recovered in the event of a court proceeding. For example, if someone were to bring evidence to court indicating that ineligible people voted, and a court determined that those votes should be removed from the total, the purpose of marking it as a challenge ballot would be that the ballot could then be recovered in that context. But that's separate from challenges to ballots in the recount process.
Am I correct, Mr. Brader, that the purpose of a recount is not to determine whether challenges were appropriately made or whether those ballots were counted?
That's correct, unless there happened to be some other issue with a ballot that was a challenge ballot that's relating to the recount.
Okay.
The other issue that was raised with regard to 101 was the oval not completely filled in, but the requirement is only that there be a mark within the oval,
Yep. And that's,
which this satisfies.
and that is clearly delineated in the examples provided here. Mr. Brewer?
Thank you, Mr. Don. I would simply add that I believe under the law, only a court can order the removal of that tape. Thank you.
I had zero intention of removing that tape, even prior to advice from multiple sources, so. I believe I would entertain a motion on challenge 101.
I move that the Board of State Canvassers reject the challenge on item 101.
I second.
We have motion and support. Any discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Any opposed?
Aye. Not opposed, but aye, sorry. Trying to get ahead of this.
Let's do that again, just for clarity.
Thank you.
All those in favor of the motion signify by saying aye.
Aye.
Aye. Any opposed? Motion carries 4-0. We are now on challenge item 102 in Genesee County, City of Flint. It looks like, based on the information in front of me, 102, 103, 104, 105, 106, 107, 108, and 109, and 110, all are, they are listed as should be an overvote. They are in different parts of the state, but if they're all the same issue, perhaps we'll address them together. I guess we won't really know till we start opening them, so I'm going to go ahead and open up number 102. Again, this is Genesee, City of Flint, should be an overvote. Proposal 22-3, we have here another instance, as we've had multiple instances of today, somebody filling in both, looks like they filled in yes, they decided, actually, that's not what I wanted to do, I want to vote no on this, so they X'd out the yes. There's some kind of, again, would appear to be their initial, which we have also addressed previously, that is not any reason to disqualify their ballot. So I will pass this around, and while we're doing that, why don't you send me 103, and I'll see how similar it is, and if we want to take these one by one or in bulk.
Looks okay to me.
This one, slightly different in terms of their markings, but virtually the same. It's the same issue where they've accidentally filled in a choice, then went back and realized their mistake and made multiple efforts to let us know that they wanted to vote yes on this. I think it is, again, clear based on the intention in looking at this, which again is part of this process, where there are questions to do the best to determine the intent within the law and erring on behalf of the voter. So this one, in my mind, would be the same issue, but I'm certainly open to hear thoughts from my fellow board members.
It's the same. I think it's the same issue. And by the way, also, I think it's extremely clear what their choice is.
Right.
This one, proposal 22-3, they have voted yes and no, but next to no, they wrote the word void. Fairly clear that they wanted to vote yes. And so, fellow members, keep them coming if you want. I'm not hearing anybody object to this. That wasn't an invitation, Mr. Hartman.
Chairman Dodd, I'm inquiring as to whether or not you determined if this is an absentee counting board or an in-person vote. In both cases, the machine is required when it's marked like that to reject the ballot. And my concern is if it is an in-person vote, proper procedure would be that the voter would be told that their ballot could be spoiled and they would resubmit, or the machine would accept it and no vote would be cast for that race. So I'm concerned that the machines are misprogrammed.
I think the issue of machines and things being spit out or duplication, we have an instance where a recount has been requested, and therefore these ballots are being looked at by individuals who are then making determinations. That is likely why there might be a discrepancy in what the machine may have done and what now this is providing through the recount process.
But following that through logically, if you were at the precinct, that appears to be a precinct ballot. If you were at a precinct and you fed that into a machine, that would become a spoiled ballot. It would not go into the machine, marked both ways. And therefore, either the machine has overridden its programming, or that should have been marked as a spoiled ballot. You would never see a ballot that's overmarked like that if the machine is programmed and we are following election procedure. That tells me that that somehow has circumvented our election process. And it's not an isolated incident.
Can you address that, please, Mr. Berger?
Sure. So there's multiple ways that this could have occurred. So one, you could have a situation where a person voted in person, corrected the ballot that way. The tabulator rejected it because it read it as an overvote. And then the voter chose to have the ballot accepted with that overvote. And then subsequently, during the recount, human beings would determine that's how the person voted. Similarly, with an absent voter counting board, they could have been looking at that ballot and made one determination or the other on election day in terms of whether to count it, determine that it was a correction or not count it as it because it was a overvote, and then that could also have been reviewed during the recount. In either case, it would be possible for there to be a ballot that was being considered during the recount that had either been had treated as an overvote or as a correction. And I guess to summarize, so that this doesn't indicate that the tabulator was not working properly.
We're on 107, and as we've opened these, again, they are slightly different in terms of the exactness of their markings or how they've indicated that they made a mistake and they are correcting it, but they are all, to each of us at this point, crystal clear as to what their intent was and what they were trying to accomplish. You have not been called up?
I thought he talked.
07.
Chairman Don, he's the Wayne County one for 107, 108, 109.
Does he has he filled out a sheet?
He did go over and attempt to do that during the break.
He actually does have a sheet.
He does, okay. Then,
Do I reserve a minute to speak a public comment as well?
depends on how this goes.
What do you mean? If you don't like me, you're not going to give me...
It's not whether I like you, it's whether or not you conduct yourself approprially.
Well, sir, I'm dealing with the law.
Please,
and-
please sit down.
Sure. Go ahead. Let's go. May I see the ballot because I did not have an opportunity to review it at the Wayne County canvassing.
This is 22-3 vote. It is, the challenge is, should be an overvote. And this one is really clear. They've simply filled in yes.
May I approach to review it?
Mr. Brader, is that something we allow?
I don't want to touch it. I
Yeah,
just
mean,
want to review it.
There's no problem with him looking at it.
It's been a while since I
Not touching it.
reviewed. Thank you.
Chairman Don, if he could identify himself for the record too, when you get back.
Yeah, thank you.
Yes, Augney is last name A-U-G-H. Ed is in Nancy, E-Y. First name Scott, S-C-O-T-T, and you can refer to me as Augney.
And you are not an attorney,
No, sir, I'm more than happy to take an oath.
so do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
So help me God, I will.
Okay, you have 3 minutes, and we've looked at 107. I'm going to have 108 passed down and take a look at that as well.
Okay, the reason that I did challenge this as an overvote, regardless of the fill-in pattern, it looks on the surface that one is lighter than the other, but the problem is this: the machine does not determine intent based on how it's filled in. It determines it by position, specifically pixel position. There's no way to determine what the intent of the voter was looking at that, because it is pixel position. The computer cannot determine what somebody may see as being lighter filled in. It determines it by position. The only way it would determine by lighter filling in is if there was additional software programmed in there. And I don't know if Mr. Brader wants to speak to this.
You're mentioning lighter filling in.
Well,
This is clearly, this is much more emphatically and darkly colored in than.
doesn't matter. The computer, sir, the computer would not be able to determine intent by looking at those two ovals. It determines intent by position, pixel position.
We're not computers, though.
Pardon? Right, correct. My point is, the computer would not be able to determine that, okay? And therefore,
Getting back to the previous point that was brought up by Mr.
you're,
Hartman.
okay,
And what Mr. Brader addressed, we are looking at these because a recount has been requested.
Yes.
So that's going to lead
Yes.
to the involvement of humans.
yes,
And their discretionary decision-making.
correct. How
I
was
think
this
we are-
logged? How was this logged? As a yes or no?
107
Yes.
was logged as a yes vote.
Okay, it was logged as a yes vote.
As is 108. And
Okay.
again, 108 is quite clear that they meant to vote yes. It looks like they started to vote no, X'd it out, put their initial.
Okay, but you're gauging that this is a yes based on the amount of fill in this particular oval. Is that my understanding of what the board's determination is?
I think that's relatively clear as to what we've been basing this on. That's the whole point of voting this way, is we're
I'm just
filling
asking,
things in.
yeah, I'm asking on this particular oval, okay? Is it the determination of the board that one oval appears more filled in than the other?
Are you on a yes versus a no, or on other votes in,
This particular ballot, sir, are you determining, I'm sorry, go ahead.
Are you referring to number 107? That's the one that you looked at.
Yes,
The oval is filled in.
both of them are filled in, correct?
No, just one,
They're not. Just one is filled in.
just one. And the voter was obviously really enthused about this one and also scribbled over the yes. So
Yeah, I see two, there filled in. Is it,
Side by side. And
Yes.
The one is not an oval. The one is the
But-
word yes.
But
And the
scribbling
machine
over
wouldn't
the
hit
yes is not going to be discerned by the tabulator.
correct?
When we look at it, what we see is that this voter was really emphatic about voting yes.
Ma'am, that is a presumption. That's a presumption. Am I incorrect about that? With all due respect, were you there when this voter
Whether I
filled that
make
ballot out?
Presumption or not does not matter. Maybe.
Shouldn't we be dealing with
because
facts?
What matters is that there is a mark within the oval. which is what
Shouldn't
the
we be
statute
dealing with
requires.
facts, not presumptions?
What matters is that there is a mark within the oval.
There's a mark in both ovals, correct?
There's
Okay,
not a mark in both ovals.
I don't think I'm
Why don't
looking
you
at,
come up and look at what she's
may I
looking at.
approach?
sure?
Approach the bench. This is the one we're talking about.
Yes,
There's a mark on the oval.
yes, and there's,
That's not
okay,
an oval.
okay, they have crossed off the other and did that, okay.
Tabulator would have never seen that.
Pardon?
Tabulator would have never seen the mark through
Well-
the word yes.
Sir, with all due respect, if we could, with regard, and that's done in ink, correct? That was filled in ink.
Appears to be, yeah.
Yeah, okay. There are variations in terms of the quality of metallic content between,
You know, I've been very, very patient. We are not getting into metallic ink content.
I'll visit it
Come
in
on, man.
public comment. That is very important in terms of the interpretation of these ballots. I'll visit it in public comment. Okay, thank you.
Yes. One oh nine. Same challenge. Again, very clear. Marked no. Just realized that they made a mistake, X'd it out, filled in yes.
Is that one, may I approach to see that one again? That's a Wayne County, right? Yes.
Wayne County, is it? That's Van Buren County, right?
No, this is 109, so yes, it is Wayne.
May I approach?
Sure.
It's one that I was looking for.
60 seconds.
Okay. That uses, both ovals are filled in, and there's an X on the no. The computer, and how is that registered? As a yes?
Yes.
Okay. These computers, again, recognized by pixel position, The only way it would be able to ascertain an X there is if it had alternative reading software, which would be OCR, optical character recognition, sir. It would have to be installed to read an X. If we are talking pixel position, there's no way that software can discern which one's accurate.
Mr. Chair,
Yes, please.
Mr. Brader, on Election Day, those ballots that have the double, and I'm going to say oval rectangle because we know we have both, and one has an X through it, what would they be recorded by the tabulator on Election Day or when tabulated if they were an AV board?
Well, the tabulator would read that as an overvote, because you'd have both ovals filled in.
And we are in a recount situation, which means that these are now being observed by humans doing a recount, correct?
Yes.
Thank you.
And these are AV votes, so this would have been something that they were,
So. So when we're, Director Brader, how many added votes for yes and no in Proposal 3 occurred in Wayne County after the recount?
Let me pull up the chart.
nine. 110 would appear to be of this same matter.
Okay, 110's right there.
Oh,
Made sure you had it.
thank you. This one's Van Buren County.
So just to follow up on that, in Wayne County, following the hand count, the number of yeses increased by 2, and the number of noes decreased by 20.
Thank you, Director Brader.
On this 110, on Proposal 3, they have filled in both ovals. Then they circled the no, indicating that that was actually what they intended to vote. So this would be registered as a no vote. And the county canvassers and our representative both upheld this decision to count this as a no vote. Again, based on what we've been looking at and doing today, I see no reason to overturn their determination on that.
Sorry, Chair Don, can we just look at the envelope to make sure that that's what occurred? Okay, so yeah, the team determined that this was an overvote, so it should not have been counted as a vote for either, correct? And then that was upheld by the board. So the determination here is that this ballot should not be counted for that race.
So this one is different than the other ones.
So
Yeah,
that-
in the
so that
sense
is different.
Determination is.
Okay. So we'll handle that one separately. My apologies for the confusion.
So do we want to handle 102?
So we're on, yes.
Wait, I can, no, circled, which seems to indicate the,
But we can handle that one separately.
Yeah, I was confused by the wording on that.
yeah, I,
Yeah, I don't know.
So we've got 102 through 109, all identical in nature to the issue we're addressing. I would entertain a motion on those challenges, and then we'll move to the next one.
could we do 107 separately?
Sure?
Because I think the rest of them would be correctly identified as appropriate corrections, but 107 wasn't a correction, it was just correctly filled out.
Okay. I think that makes sense.
Okay, so,
Borrow mine.
yeah, no, I'm good. Okay, Mr. Chair, I move that the Board of State Canvassers reject challenge number 107.
second that.
So we have motion and support to reject challenge 107. Is there discussion? Seeing none, all those in favor of the motion signify by saying aye.
Aye.
Aye. Any opposed? Motion carries 4-0. We now would seek a motion related to items, challenges 102 through 106, and 108 and 109.
Mr. Chairman, are we doing 108 and 109 separately, by the way?
We can do, I think they're same as 102 to 106. We pulled 107 out because, as Member Gerwitz pointed out, it was a slightly different. 110, we have pulled back and we're handling separately. So 102, 103, 104, 105, 106, 108, and 109 are all the same, and we could address them together if we would like to.
Let's do that. Mr. Chairman, I move the Board of State Canvassers reject the appeal challenges 102 through 106, and separately 108 and 109.
Support.
Motion and support. Is there discussion? Seeing none, all those in favor of the motion signify by saying aye.
Aye.
Aye. All those opposed, motion carries 4-0. We will now make sure everything's back in its appropriate envelopes from those and address 110, because I think there was some confusion on what the envelope says and what the challenge is seeking to, address. So why don't we let Mr. Brader, if you wouldn't mind reiterating what you view the issue at hand is, and then Mr. Hartman can discuss the challenge, and then perhaps Mr. Brewer would like to come back up and address that.
So, yeah, so we indicated this on the summary as should be an overvote. Probably should have said should not be an overvote, as the original challenge. The team determination here that was made by the recount team and that was upheld by the county board and then by the representative of the Board of State Canvassers, they determined that both yes and no were marked, and that it should be treated as an overvote. And then the challenge is saying that because no was circled, that it should be treated as not an overvote, I guess as a vote for no. Is that how you read this?
Mr. Hartman, is that an appropriate explanation of your position as to what you are challenging? Or are you challenging that this should be an overvote?
Sir, I'm indicating it should be consistently applied. It appears as though your Bureau of Elections determined that something circled in 102, 3, 4, 5, 6, 8, 9 was a correction, but this one they determined was an overvote. And it has to be uniformly applied. So if this is, in fact, both are marked and it is circled, it should be a correction just like you determined on every other one. You can't now declare this one to be an overvote just because the earlier board reached an inconsistent decision.
This one was marked differently, Mr. Hartman. The way that the circling is done is not consistent with the other ones.
So is both oval, I haven't seen it, but it was described for the record as both of them were marked, yes and no, correct?
Yes.
And one of them was circled.
Yes, both ovals were filled in, and the no was then subsequently circled.
So wouldn't that indicate a voter's intent?
I think that's a fair interpretation based on what we have been doing here today.
All right. So I'm just suggesting whatever you apply has to be uniform. And if you've decided, regardless of yes or no, if a circle constitutes a correction, then it has to be uniformly applied. It appears as though the Board of County Canvassers and the Bureau reached inconclusive decisions on identical issues.
And part of my issue has been figuring out exactly what the determination was and what the challenge is. I think I understand it now, and so I think I have an idea of what, in my mind, how to proceed.
All right. Before you do that, I just wanted to, my last comment, and then Mr. Brewer can comment, is related to the determinations as to 102 through 106 and then 108 and 109, because that was a human catch, that should have resulted in a variation from the machine tally. So did each of those precincts, if you were to confirm, that would mean that because the humans caught something that the machine would have had to reject because it would have read it as an overvote, and we've just determined that a human has now determined and corrected it. In every case, there should be a increase in the number of votes that were counted. And if it is not an increase, that would indicate a problem with the machine. And so I'm wondering, related to 102, 3, 4, 5, 6, 8, and 9, whether or not the determination that the Board of County Canvassers made, that was affirmed by the Bureau of Elections, which was affirmed by you, resulted in a change in the ballot determination from what the machine had made at the precinct. Because if not, then we would have a problem.
I think it's quite clear that those could have been determined when the ballots were initially tabulated. This is not something that was only revealed during a recount, because when the ballots are tabulated and it does not get tabulated, then it gets examined. And the people who are tabulating the ballots on Election Day or shortly thereafter can correctly count the vote.
It doesn't jive, because in an in-person precinct, it would have to result in a override, which means it would.
These are absentee ballots. All of them.
But in a precinct, it would have been an overvote, and therefore it would have either been a spoiled vote or it would have been an override on the machine. And therefore, once we have now determined it's a valid vote, it would change the outcome from what the machine was. As to an absentee counting board, if it would have gone to adjudication, that software, the adjudication software, would once again have nullified the vote, unless somebody had already altered that digital ballot.
Mr. Hartman,
You
can I ask you,
misunderstand, I'm sorry.
can I ask you a question? Just a what if? Because we're doing what ifs, so let's do one. Let's say that I'm in a precinct and I'm voting, and I know this happened. And I'm voting, and for whatever reason, the machine got jammed, and this happens to be a true incident. Machine got jammed, and the election worker, instead of having people run through their ballots, they collected those ballots, put them into the bottom of the machine manually with witnesses, proper procedure, and promised the voter that when the machine was brought back up, the county clerk or the elections people would run those ballots. Is it possible that those marks ballots that you said, is it possible that the machine had gone down and those were run through later?
There'd be evidence in the poll book, which you would have to make a determination to make that call. I mean, it's possible, but in
But isn't that as realistic as any other explanation?
well, that's the reason that we've requested an investigation. So in this case,
For the 1,875th time, we are not an investigatory body. Mr. Brewer.
Thank you, Mr. Chair. Let me deal with this procedural argument here. There's a far simpler explanation. Look, the recount replaces the prior result, so you're counting from fresh. And you can't just pull one challenge out of context and say, oh, that should have made the total go up or down. I suspect that in these precincts, as has been reported, there were variations in the vote which were not challenged. And that is an equally valid, and I think much more plausible explanation than there's some suspicion here of nefarious computer programming. So that procedural objection, I think, has no merit whatsoever. I would like, Mr. Chairman, on the Van Buren ballot, which I've not seen before, if I may approach and look at that ballot before I respond.
Absolutely.
Thank you.
You bet. And to reiterate, I'm going to try to reiterate this without following it up. My understanding is that ultimately it was initially determined that this was an overvote, and the challenge would be that it should be recorded as a no vote because it is circled. Given the discussion we had hours ago, I think at this point, about what's listed as examples and then bringing into our judgment. I think in light of the things we have accepted and as being, expressing the intent and maybe not being exactly as laid out, but we are humans, we're here to make these judgment calls, and if people have a problem to proceed, I would be inclined to accept the challenge and count this as a no vote. Mr. Brewer.
Yeah, you have conflicting principles here. We've urged and you've respected the decisions of your local boards today. But frankly, the default position of promote the vote is to try to enfranchise, not disenfranchise voters. So we would have no objection to have a promote the vote if this vote is counted and it is not regarded as an overvote.
Are we on reproductive freedom? We're on proposal 3, right?
Correct.
Not promote the vote, correct? Okay. Just want to make sure.
Member Bradshaw, we just want to, our ultimate goal here is to make sure that votes are counted and people are enfranchised, and that's my final principle, default position on everything.
Yeah. The only thing, if I could just point of clarification, this was a different county. This is Van Buren County. So we had a different county board and a different bureau staff member that made a different determination. I think, having viewed the ballot, I can definitely see the argument that that should be a no as opposed to an overvote.
Okay.
Mr. Chair, I'll make the motion. Mr. Chair, I move that the Board of State Canvassers accept the challenge for item, I believe we're on 110?
Correct.
I second that.
Motion and support, discussion. Seeing none, all those in favor of the motion signify by saying aye.
Aye.
Aye. Any opposed? Motion carries 4-0. We are on
111.
Sorry, Adam has a question.
I just want to clarify, so in the sheet that you guys have, because you've accepted the challenge, just for the record, that will adjust the numbers in Van Buren County specifically. So the the original for the precincts was 1,691. That will remain unchanged now, so the new recount number will be 1,691 as well. If that makes sense, and I can say it differently if it didn't make sense. Okay.
And will the acceptance of that cause any need to adjust documents or motions to the point of needing to take a break to reprint or anything like that? Or is that we will be set with minutes reflecting that we accepted this?
So I can, if you would like, I can have this reprinted. Ultimately, so the sheet that the board has in the packet and the sheet that is on the Bureau's website with the unofficial recount results, the version that is on the website will be updated to reflect the board's action. If you would like to have the version in front of you, I can have staff correct that and print it and bring it over before we're adjourned, or while we're finishing the remaining 9 challenges, I think. Or if I think the record is clear by accepting the challenge, and then if we tweak the motion just to say.
If the record is clear and there's no confusion here, and the records moving forward will be clear as to what we have done here, I do not think it's necessary. But again, I'll defer to my fellow board members or others.
We're fine.
Sure, we will take a 5-minute recess. All right, calling this meeting back to order at 2:35 PM. We have just under 2 handfuls of these left to go. I think it would be beneficial, I think was some side discussions after, when we adjourn, or not, when we recessed, about, why sometimes a challenge in overvote decisions impacts the totals and sometimes it does not. And Director Brader indicated he could explain that, which I think would be very helpful to folks who may question, well, if there was an overvote, but you guys decided to flip that, why didn't it change results? So, Mr. Brader?
Sure, yeah, so I mean, one explanation is what was discussed before, which is that you're recounting the whole precinct. So you have to look at the total picture. So you could be one up for one reason and one down on another reason. But the other difference between certain jurisdictions is it'll depend on if they're using adjudication software or not for the absentee ballots. So a big jurisdiction like Detroit, several other large jurisdictions, in the absent voter counting board on election night, there is a bipartisan team of election inspectors who are looking at a screen that's bringing up the image of the ballot on election night after it goes through the scanner. And they're making that same determination that the board's making, or that the county boards are making right now when they see some of these overvotes. And they may use that software on election night to actually indicate that it was a correction, and so it doesn't go in as an overvote. In that case, the recount team might just be making the same determination that they made on election night, so that's not going to change anything. If it's a smaller jurisdiction or jurisdiction that's not using that software, then it's just going to go in as an overvote, and no one's going to know that unless you pull it out for a recount. So it'll depend to some extent on what equipment was used to tabulate the votes.
Thank you, sir. With that, we will move to challenge number 111, Genesee County, Grand Blanc Township, absentee vote counting board should be an overvote due to bleed through. Ballot should be counted as overvote because of bleed through. The County Board of Canvassers and our representative disagreed with that. Can tell that, where is it here? This is clearly a no vote, and it does suffer from some of the same bleed-through issues we saw in previous ballots earlier today, but is not impacting their filling in of the square or the oval. Therefore, see no reason to accept this challenge. It's very clear it's a properly voted ballot. 112, Wayne County, Livonia, absentee vote 21A. Should be an overvote due to bleed through. No, you may not. (22-3). This is a no vote. This also has some bleed through issues. They are not impacting any of the ovals, in particular the oval of what was part of this recount, which was Proposal 3. Therefore, we should reject, in my mind, we should reject this challenge, and this should be counted as a properly cast ballot. So that is 111 and 112. Same issue. I would entertain a motion once my fellow board members are done reviewing on these two items. (111) and 112. Sure.
Mr. Chairman, I move the Board of State Canvassers reject the appeal challenge for item 111 and 112.
Support.
Motion and support. Do we have discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye.
Aye.
Any opposed? Motion carries 4-0. We next have item challenge 113. It would appear that 114 and 115 are of the same nature. First one is Genesee County, Grand Blanc Township, and it is ballot should not be counted because of stray marks. County board and our representative said we should count it.
Mr. Chair, we're only going to take 13 and 14. I'd like to see 15. 15 we're going to do separately. That's why I was letting the chair know that we were doing 13 and 14.
Thank you. So, this is a yes, and it looks like, I guess you could say bleed through, which could be construed as stray marks. There's also a very slight stray mark across, like somebody maybe dragged their pen across a little box here, but otherwise, using the same eyeball review of the previous ones, I do not see any reason to accept this challenge. Yes, 90 seconds.
It's just a standard bleed through. Like to see it?
Mr. Chair, I just have a question, and it's not, these have already gone through
You'll see.
the county board.
They line up.
They've already been reviewed
So
by
it's just-
individuals, and then we're
here's the mark and
reviewing them
stuff.
again? Okay.
Yes.
Is that one okay?
So that's 113. This one is Muskegon County Fruitport absentee voter count board, stray mark. This would appear to be bleed through as well, which just based, people have different terminology for certain things. So again, I think there's no reason to accept this challenge. This, though messy, still is easily discernible what the intent is. So with that, I would,
It's, again,
Mr. Hartman would like to see. I would entertain a motion once you are done reviewing
5.
for 113 and 114.
Those bleed throughs marked the same. Let me do a motion. I'll do the motion. Mr. Chairman, I move the Board of State Canvassers reject the appeal challenges for 113 and 114 for stray marks.
Second.
Motion and support. Is there discussion? Seeing no discussion, all those in favor of the motion signify by saying aye. Aye. Any opposed? Motion carries 4-0. We are now on challenge number 115. Going to open this up. It would appear, based on a little brief conversation just prior to this, that Braden, you would like to speak on this? You just want to see it? Okay. So this one also says distinguishing mark / stray mark, and the decision is that it's a valid vote. The county board has accepted and our representative agreed. So the challenge would be to reject because of the stray mark. And yeah, I'm just trying to make sure. So here we have, okay. So we have on here, it's a yes vote. Down at the bottom, there is a name and address and something else, some number, but essentially it is.
Can I take a photo of that? Why? Are we certain that's the voter then? Can we have an investigation to prove what you just said? Please.
The issue with the picture is that this is that gentleman's private information. I think if there was a court proceeding related to this, then you would, this type of information would be appropriately discoverable in public information. I'm not comfortable having this become part of some kind of social media expose or something like that, so.
Okay.
I think we have an issue at hand here about an identifying mark. So I think we need to address that and adjudicate that. If you would like, actually would prefer for you to make your comment about what you think we should do prior to this.
I'd just like to go over how this ballot was found. This was a challenge that I made at the Wayne County recount, and it was very clear that it appeared there was a name on that ballot along with perhaps an address or phone numbers or all kinds of, it was like a novel. And so I made a challenge as a distinguishing mark, and my good friend, Mr. Brewer over there, jumped up and said I couldn't make a challenge on it. And then he looked at it and looked startled for a moment and then said, "Oh, that's just a stray mark." Yeah, that's pretty funny. And then, so I had a good chuckle too, because my eyes, I guess my eyes are really bad, and I thought I saw a name on there. And so I said to Mr. Brewer, "Mark, that's a very, very specific stray mark, isn't it, Mark?" And he said, "That's all I see is a stray mark." And I just want people to understand here the obstruction and intentional malfeasance by Mr. Brewer and his entire team throughout the entire day there and throughout this entire process, where they obstructed our workers and intimidated them and harassed them with things like what I just said. But it gets worse. Then, when he saw me take out my phone, which I wasn't doing anything with, he then jumped out of his chair again after trying to argue that I couldn't make this challenge. And then he said, "Oh, you can't take a photo of that." And I said, "Well, I wasn't taking a photo of that." And I said, "Can't take a photo of what, Mark?" And then he proceeded to say, "Oh, well, there's clearly a name written on that ballot." Because he's a deceptive, disingenuous, and manipulative little weasel.
I've asked, hey,
So, sorry, I apologize. He's deceptive and manipulative. Deceptive and manipulative.
him speaking about
I apologize. I withdraw. I apologize, Mark. My good friend, Mark Brewer, is deceptive and manipulative, and that's a very clear indication, based on the story I just told you, that that's exactly what happened. And he was like this throughout the day, and this is how he instructed his people to work. And that's not how a recount should be done. And something needs to be done about my good friend here.
Mr. Brewer, would you like to perhaps give him?
Thank you, Mr. Chairman, and I'll stick to the merits and not engage in personal attacks. My argument before the Wayne County Board was just vastly mischaracterized. In response to this challenge, I'll point out several things. First of all, the challenge was unanimously rejected by the Wayne County Board, and you have today been deferring to your local boards. It was upheld by your staff member. Now, arguably, and that's arguably at best, somebody signed his ballot. But there's no proof that it was the voter who cast the ballot. And this ballot will never be seen again unless a court orders it to come forward and be investigated. And so I think what we've got here is a situation where you're being asked to disenfranchise this voter based on an unexplained signature, allegedly, address, whatever the information is, that again will never be seen again and should not be used as a basis to disenfranchise a voter in this fashion. without any further proof, which has not been provided either at the Wayne Board or here today, about who signed this. Was it the voter? Was it not the voter? There's just a lot of unanswered questions here. And without further proof, again, I just ask you not to disenfranchise this voter as your colleagues on the Wayne County Board and your staff so indicated.
We are not allowed to investigate or take photos of anything, so how could we possibly do anything that he's saying except through you or through the county? And also, I would like the board to address the fact that he obstructed our people and harassed them and intentionally manipulated them to try to get incorrect outcomes in this recount.
So on the second point, we were not there to witness what went down, and we're left with a he said, and I have absolutely zero interest in getting involved with that with my daughter and my niece when they get in disagreements. I'm certainly not going to get involved in it with each of you.
So what are the rules on that, though?
I think what we have, what's at issue and what's at merit here is that in legal or staff, it is against the law to put a distinguishing mark like this on a ballot. Is that correct, or am I slightly off base on that?
I guess I'll go
80318.
opinion, but the legal advice needs to come from the Attorney General. So, if a ballot has been, the exact wording of the law, I'll just read that.
So is this a stray mark now, Mark, or is this a
If it's,
name?
what the law says is, if it is clearly evident from an examination of a ballot, thank you, that the ballot has been mutilated for the purpose of distinguishing it, or that there has been placed on the ballot some mark, printing, or writing for the purpose of distinguishing it, then that ballot is void and shall not be counted. So the determination here would have to be whether it is clearly evident from examining this ballot that there had been placed on the ballot some mark or writing for the purpose of distinguishing it.
And is that perhaps either you or one of our council can address, is that language directed at the voter making that type of mark, or somebody within the elections process doing that? Where I'm a voter, if I want to sign my name and say, yippee-ki-yay, who's to stop me? That's my ballot, and it gets to the point Mr. Brewer's making of why would somebody disenfranchise me for that. Mr. Giacobazzi, sorry if I'm mangling your name a little bit.
Perfect, it's fine.
The argument of this is a distinguishing mark, and maybe somebody from the elections process wrote it on there to, who knows what their reason was. I think there's somewhat of a distinction there in terms of who that language is directed at.
Looks like it's a ballot. It looks like they put their name on it, the date that they sent it in.
So if you folks couldn't hear what my fellow board member said, he essentially said it looks like it's an absentee. They put their name on it and the date they sent it in, which would tend to indicate the voter did this, and he did this because he wanted to make sure that if it got separated from its envelope, that somebody knew that this was, his ballot, and he got credit for voting. Again, we're making a lot of assumptions here. I think there's a legitimate concern of identifying information. The issue in my mind is what was the intent, and I don't think we should just brush it aside and say, hey, well, we're never going to know. I think that's too cavalier towards the issue we're dealing with. I don't want to simply, I don't want to simply toss this individual's ballot because of this. So
Chairman Don, if I might.
we get some, are you doing some, looks like our council is looking into this, so Mr. Hartman?
It's in our Constitution. And in addition to that, at a poll, Mr. Brader can confirm this, if a person shows their ballot and breaches the secrecy of the ballot, that ballot is also void. And so you're not disenfranchising the voter. The voter's given clear instructions, the law is there. So we can't have this holy grail of disenfranchising voters trump a clear, unequivocal statute. So this ballot is no longer anonymous. I don't necessarily think that we're at a point where we shouldn't have, we should even have secret ballots, but the fact is that's the law. And the law is once a person makes a distinguishing mark by writing their name on it, that is no different than showing the poll worker your ballot before you vote it. It would be void. And therefore, we didn't disenfranchise the voter disenfranchised themselves by not following the rules. And you have to enforce the law.
And I'm just to give you an opportunity to clarify something. When you said about not having secret ballots, I'm taking you to mean kind of like the ballot selfie, where if somebody wants to display their ballot, they should be able to. You are not saying everybody should be public in who they're voting for.
Well, let me just say this. I don't believe that ballots are anonymously voted. You can look on social media and track how people are voting. You here are voting in public, right? When you make a vote, you're doing it in a roll call.
So I was trying to give you the benefit of the doubt. You are steamrolling that, and you would prefer people to vote and have to showcase who they voted for.
I'm going to tell you.
You can have that opinion.
That's irrelevant. I shouldn't have made the comment. It is a trail we do not need to go down on public. The law currently is that a ballot is anonymous, and that if it is identified, it is void. And that is true in the case of an in-person vote or an absentee vote. And when you make a distinguishing mark, you cannot avoid the plain language of 803 says for counting or recounting. And if you read the 803(1)A, if this isn't a distinguishing mark, that statute is basically meaningless. And you can't ignore the law.
Got anything?
Well, I think with respect to the question you asked about whether the 803(1)A distinguishes between an elector who might cause a stray remark or some sort of mark, or an official, some sort of election official, the statute doesn't say either way. I think it can be read to anybody who places, some type of distinguishing mark. So the question really is, as Director Brader had read the statute, the question is whether the mark was placed on there for the purpose of distinguishing the ballot.
Okay. So, yeah.
May I, Mr. Chairman?
Yes.
There have been a number of things that I'd like to respond to. I agree with that point. You have no evidence that this was whoever put this on there at whatever point did it for the purpose of distinguishing this ballot. It's all speculation by the challengers as to what the purpose was, and so it doesn't even fit within that statute.
So how could we ever get that since we're not allowed to do that investigation? Who would do that?
He let you speak without interrupting. I'm just asking for the same on both sides.
Fair enough.
The other point we've heard here is that, well, what's the remedy? There is a court remedy that is available to folks. If they think there is something improper about this ballot, as with all the other challenges you decided today, they can go to court. Finally, I would indicate, until now, this ballot and its possible identity with a voter has remained secret, notwithstanding the efforts of the challengers at the Wayne County Board of Canvassers to take a picture of it. And as you stopped here today, Mr. Don, this ballot is secret. There's been nothing done that exposes this voter who may or may not have signed this and violated his or her right to a secret ballot. So I'd urge you again, the default position should be allowing the voter to express their vote, not disenfranchise the voter and turn down this challenge.
Anything?
So I would say that we've brought it to your attention that you have subpoena power. That investigation can be started by you, or you can refer it to anybody you'd like to. But the questions he's asking are exactly why we brought it here today and why we're expecting something to come of this. But he just wants to sweep it under the rug, clearly by his actions.
May I, Mr. Chairman? We do not want to sweep this under the rug. We're trying to protect this voter's right to vote and his or her privacy. They have a court remedy if they want to go down that path. Again, I'd urge you to reject the challenge.
And I'm still confused whether this is a voter or just a stray mark.
Okay. Questions or discussion on this, what's at hand among my board members?
Yeah, it looks to me, and this is speculation, that the voter made a mistake. They know that they have to sign the return envelope. This is an absentee ballot. So the voter perhaps signed the ballot. It's more likely that the voter did this than that someone else did. But I think we cannot possibly say that the voter did this for the purpose of distinguishing his ballot. Voters would not anticipate that would happen. The ballots just get fed into the tabulator. Distinguishing them is clearly not the purpose of his signing the ballot. We could at least, as we have earlier, deferred to counting rather than discounting a voter's vote.
Yeah, just very honestly, this is certainly the most difficult one in terms of a decision, as I see it, because this is, like, they've made a distinguishing mark. Now we're into the interpretation of what was their intent. We've also been deferential to the previous decisions, and we've been deferential to the extreme in respecting the franchise of individuals. I think ultimately in this instance, I would be inclined to respect the franchise of the individual on this. And it definitely is a difficult case because of the specifics.
Could it be more specific than what's on there as a distinguishing mark? Could you possibly ever be any more specific?
I think the issue is what they mentioned with, the purpose or reason or whatever the word they had used in the statute behind the marking. And
Yeah, again, this is a human process. This is a human process, okay? And so this isn't a guess as to whether this is an absentee ballot. This is an absentee ballot. This is somebody who mailed it in. We can guess at who the identification is. I don't know that would be all that hard to figure out. Quite frankly, there's enough information there that we could call the individual on the phone in about 20 minutes and simply ask them. But this is a human problem, and I think it goes to a different issue. It goes to the issue of sometimes this stuff requires common sense, and sometimes it requires what a vote really is all about and what's underneath it. And in this particular case, I would side with Mr. Brewer because I think he's right. There's no reason to disenfranchise a legitimate vote. And to make this into something that's an illegitimate vote, I think is you using a statute and interpreting it in a way that it becomes a hammer rather than it becomes something useful to uphold an election.
Mr. Daunt said this was clearly the most difficult one that he's had to look at today, and you agree with that, and yet you're telling me that I'm applying the law improperly. Well, you are applying moral uncertainties to this, where I am looking directly at the law, and we are governed by laws, not men. And so what you are doing is absolving yourself from having to deal with the law by appealing to emotion. And I don't think we can do that here.
No, I think you're quoting the law. I think you're quoting the law in a way that may not be appropriate.
It wouldn't be the most difficult one of the day if it wasn't appropriate.
And I'm not disputing the appropriateness of you bringing this challenge. We have to make a decision.
Yeah, sure.
And I'm talking to him.
I got it.
And ultimately, this is an issue of enfranchisement or disenfranchisement of an individual. And regardless of what the marking indicated of their yes or no, I'm loath to toss their ballot for that reason.
I understand.
What is that?
I understand.
Is the statute a long statute or is it a short statute?
The part in question is fairly short.
Okay, so it's only a couple of lines, right? Could you like just read it for everybody, just in one read through, just as a record?
This is MCL 168803, subsection 1. Subsection 1 has several subsections. I will specifically limit it to section 1A. Except as otherwise provided in this act, the following rules govern the counting and recounting of votes. If it is clearly evident from an examination of a ballot that the ballot has been mutilated for the purpose of distinguishing it, or that there has been placed on the ballot some mark, printing, or writing for the purpose of distinguishing it, then that ballot is void and shall not be counted.
Distinguishing it means it stands out from other ballots.
Why else would somebody put their name on something if not to distinguish it from other things that don't have their name on it?
We have at least a half a dozen of the most brilliant legal minds in Michigan in this room. We're just going to see what the word distinguish means a minute.
Mr. Lidl wants to address the distinguishing.
Distinguishing is not defined in the statute.
I may have some additional information to assist the board in its duty to faithfully execute the text of the statute as enacted by the legislature in full. We do know that this is an absent voter ballot, which means that the provisions of Article 2, Section 4, which were adopted by the voters in 2018, apply. The statute predates that. The Constitution certainly prevails over any other, and it provides you with some guidance with regard to how to interpret the statute at issue. It's Exhibit C in the packet that we distributed, so if you're interested in actually seeing the text of Section 2, or Article 2, Section 4, under that provision, every citizen of the United States who's an elector qualified to vote in Michigan shall have the following rights. That's sub 1. Under sub B, the right of serving in the military to vote an absent voter ballot. We don't know if this person is in the military. Based on the evidence before you, we do know that this was an absent voter, which implicates subsection 1G, which indicates that they have the right, once registered, to vote an absent voter ballot without giving a reason, and to apply for, receive, or submit the ballot in person or by mail. Then the Constitution, as approved by the voters of Michigan, goes on. All the rights set forth in this subsection shall be self-executing. That would include the right to vote an absent ballot, which this is. And then in terms of interpretation, we have guidance from the voters as well. They have said, quote, "This subsection shall be liberally construed in favor of voters' rights in order to effectuate its purposes." So that imposes a constitutional duty on this board to liberally construe the statutory provision that predates this constitutional provision in favor of the voter's rights to cast an absent voter ballot. And so that would further weigh in favor of counting the vote, given that you lack any evidence with regard to the purpose of the mark. Thank you.
Thank you.
Chairman Dalt,
Why didn't you get up and say that earlier, Steve? I'm
a
looking
non-sequitur.
through what you've provided, and that you do reference that, so thank you for the clarification. Mr. Hartman.
so the constitutional amendment was dealing with the change from a requirement that a person to vote absentee had to have an excuse and pick up their ballot at the precinct. We went to mail-in, no excuse absentee ballots. So when we're talking about liberally construing the rights, we're talking about the right that is granted specifically, which is the right to vote absentee, not the right to disregard the other statutes. As an attorney, he knows darn well that the rules of statutory construction require that you interpret things in harmony. These statutes are not in conflict. And that is like saying that because it's a Wednesday, that's not relevant. And what I'm suggesting to you is the constitutional right that was given and afforded to a person to vote absentee as a no excuse and be able to do it by mail has nothing to do with the manner in which the legislature has stated that they would void their vote for not following the instructions that are given. And therefore, the constitutional right that is implicated in this has nothing to do with the case or controversy we've raised here. And listen, I'm not trying to disenfranchise anybody, but I will tell you that one of the things that we have to make sure we understand here is we either follow the rules of the law or we don't. And what I would suggest to you is that you cannot look to the overall rights that we've granted voters to have a right to vote absentee to say that means that they can vote any way they want. I mean, there are rules to how you can cast a vote, make a vote that's clear so that we're not making case-by-case decisions. I would go back and say that more importantly than the Michigan Constitution is the United States Constitution, which was interpreted in Bush versus Gore, that indicates under equal protection there are three rights. Not only the right to have access to the ballots, but the right to have your ballot counted as you intended and cast, meaning that it's a clearly defined mark. And third, not to have your ballot diluted by somebody not eligible to vote. And the reality is if we're going to just say that all the election rules and all the procedures don't apply because all we have to say is the person turns in a napkin and it's not on an official ballot, but they've marked on there that they have voted for Mickey Mouse on square one and they voted for yes on proposal 3, that we have to take that napkin, that would be ludicrous.
That's,
Because we don't comply with.
Mr. Hartman,
Nowhere near what
that's
this
not what's
involves.
being discussed here.
No, but the reality is we have a rule that's not being followed. And it becomes ludicrous when I mention a napkin versus an official ballot, but that's just another law and rule that's still disenfranchising the guy who sent the napkin in.
Chair
Thank you,
Dot.
sir.
Thank you.
Chair
Yes.
Dot, could I just bring something to the board's attention? We've also looked at Administrative Rule 168.923, so that's a promulgated rule that's, deals with the distinguishing marks. So it says, the following rules shall govern the recounting of votes. Sub A, where it is clearly evident from an examination of any ballot that the same has been mutilated for the purpose of distinguishing it, or that there has been placed thereon some mark, printing, or writing for the purpose of distinguishing it, then such ballot shall be void and shall not be counted. The following criteria must be met to find a mark or mutilation to be distinguishing. Little I, it must be clearly evident, little 2I, that the mark or mutilation was placed on the ballot by the voter, and little 3I for the purpose of distinguishing it. So there are some additional criteria that are set forth in the administrative rule in support of of the statute, which is 803A, 803-1A.
Okay, thank you. Okay. I would expect we've exhausted the discussion on this, and I would entertain a motion. This is again, this is challenge 115.
I move the Board of State, I move the Board of State Canvassers reject the challenge set forth in 116. I'm sorry, 115.
So the motion is reject, restating for clarity, your motion is to reject the challenge of number 115.
That's correct.
I'll second it.
Motion and support. Do we have discussion? Okay, seeing none, all those in favor of the motion signify by saying aye. Aye. Any opposed? Motion carries 4-0. Number 116, too little of a mark. This is Wayne Livonia. Would be, this person didn't really follow the instructions all that well, but it is clear what their intent is. I mean, given that they have marked used the same method for a proposal, another proposal, and I won't bring in the other side of the ballot because that was not part of this. I think that is a fair interpretation that this should be counted as a valid vote. I'll let others take a look at it and let me know what you think.
So the person has made something that approximates a check mark, but it is at least somewhat within the oval. So as long as it is within the oval, it is a valid mark.
And none of this disposes of my frustration with people who do not follow the instructions and make it a little more clear so that we don't have to do these type of things.
Oops, where did it go? We have in some recounts examined the ballot with a magnifying glass to determine whether or not the mark was within the oval. And it seems unduly picky, but again, that is respecting the right of the voter. And I don't think we need a magnifying glass to see that this mark is within the oval. I did think of bringing a magnifying glass, but I didn't.
Chairman,
Mark has
not
one.
needed it.
Mark is always prepared.
briefly, I would cite to you 803.1C, which states marks other than crosses or check marks used to designate the intention of the voter shall not be counted. Goes on to talk that it requires a line that intersects within the circle or the square. And this is clearly defined as what is a mark and what is not a mark in the statute.
Mr. Hartman,
Based on the intent of the voter, you're just indicating that the statute does not apply.
Mr. Hartman, I will point to a few items ago where we had a difference on overvote versus counting and respecting the intent of the voter. That was clearly not something laid out as an example or things we had seen before where they filled them both in and circled one of them. We allowed that to move forward. I see no reason to not be consistent in what we have shown to be as deference to the voter's intent in this process. Again, a lot of this comes to light by virtue of a recount being requested. And when that happens, it's incumbent on the people participating to respect that voter's intent and to take every step possible to respect their franchise.
And sir, I appreciate that, and I would just echo the remarks of Braden Jacopozi, who just indicated that that is a decision where we are balancing a value of the voter's franchise against the statute, And the statute is clear, 803, subsection 1C is very clear that does not constitute a mark.
I would entertain a motion, or anybody else have a comment?
I move that the Board of State Canvassers reject the challenge of 116. 117, I'm sorry.
No, it was
Or it's
116.
116, yep, sorry.
Would you, we didn't have a second, so maybe just withdraw that and say it again?
All right, I will withdraw and I'll start all over again. I move that the Board of State Canvassers reject the challenge for number 116.
I'll second.
Motion and support. Do we have discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Any opposed? Motion carries 4-0. Item 117, Muskegon County, looks like City of Muskegon Absentee Voter Counting Board. Voter used green ink. And 118, voter used green ink. Proposal 3, clearly marked as yes. Frankly, green is my favorite color for a variety of reasons. Go green as one of them. I need more money as another. This looks blue to me, frankly.
I think it looks turquoise.
Ultimately, I don't see any reason to reject this ballot because of that. And when I look at 118, that one is green, and through certain portions of here, it looks like they tried to cover over with blue. Don't know why they didn't continue, but again, they're clearly marked. They've been opened up for us to take a look at, and I see no reason to reject them. Mr. Hartman, let me hear why you disagree with that.
I'm just going to cite the law, and I'll let you decide the voters' franchise trumps the law. 168.736D states, important, to mark your ballot, these are the instructions that are required to be given. Important, to mark your ballot, use only a blue or black ink pen. Do not use any other ink colors. Now, the second problem that I have is related specifically to the 117 is the color of the ink is the issue, but in 118, the problem is with that one is that part of the ballot is in a different color ink. And so it isn't certain as to, without an investigation, whether or not a person made all of those marks or marks were added later. But one of the things that I would tell you when you're judging marks on a ballot, it says to look to see whether it is consistent. And in this case, you have a difference in colors of ink on the face of the ballot, and that is concerning of itself.
Both of those, once again, just to note, both of those in question are, again, both absentee ballots. Not that that makes a difference.
That's why we have instructions, we have a voter
I get that.
education program, and the reality is that's just what the law states, and if it's the voters' franchise governs over that, that's your decision. But I would indicate that I'm here to tell you what the basis of the objection was. I didn't make it. It was based upon a good faith belief that the law states that. And the second one, as to 118, we are asking you to make a determination that there were two inks, and without an investigation, that raises at least some inquiry as to why there are two marks made with different colors on the ballot. I would note,
Have you ever been using a pen and it runs out of ink? I mean, Mr. Brewer, it looked like you wanted to come up and address the issue.
Thank you, Mr. Chair. The quote that you heard from Mr. Hartman are the instructions.
I was going to ask that question of the staff or that it states the instructions, not that it has to be done that way, and thank you.
And finally, I would also point out, echoing what my colleague, Mr. Lidl, said before, the statute predates the constitutional amendment, which now creates a state constitutional right to vote by absentee ballot, and the statute, I think, frankly, is unconstitutional if it's interpreted to restrict an absentee voter to a couple colors of ink. So, thank you, Mr. Chairman.
In those instructions, I would imagine, I'm seeking input from our experts down there, are blue and black are going to be the easiest to read by machines, and so people are being instructed to use those so we don't have these situations. Am I correct in that interpretation or understanding? And that it is not to be construed that if you use a pink pen, your vote should not count?
We've never interpreted this to mean that if you don't use black or blue ink, then your vote is disqualified. So, I mean, the instructions, I would note, also say completely darken the box. We have many incidents where people do not completely darken the box, and yet the vote is still counted. And I think for most people who filled out a form, Scantron test in high school or whatever, you often see instructions like this, but we have not interpreted these to be prerequisites for having your vote counted.
Okay, I would entertain, go ahead, sorry.
Your last piece there is that 117, I would argue that that's not green, that's aqua. And last I heard, aqua was still in the family of blue. Maybe that's debatable.
I would just
Mr. Hartman, I think we're all set. I would entertain a motion on these items.
Mr. Chair, I move that the Board of State Canvassers reject the challenges to, make sure I have the right ones this time, 117 and 118.
Say that,
The motion is to reject the challenges of 117 and 118.
so yeah, I thought she had a different number in there. Yes, I will second that.
Okay, we have motion and support. Do we have discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Any opposed? Last one. Challenge 119. This is Wayne County, City of Detroit, absentee vote count board. Wrong ballot issued or voter moved. The ballot is duplicated. That's a lot of words that seems like Mr. Brader or somebody's going to need to kind of explain what's going on here. Shall we? Put glitter in here? So there are two ballots in here. We have original and duplicate. And what we have here is the original is City of Detroit absentee vote count board 4. And the corrected, duplicate is City of Detroit absentee vote count board 6, which would lead to get to the issue of this was that this person moved and were therefore provided an incorrect ballot. There was some mistake in that process. It was caught and corrected, and this individual was given a new ballot. And I'm looking at the wrong side. And in this instance, on proposal 3, on the original, they were voted yes. On the duplicate, they voted yes. And certain things are changed because of being different section of the city, so slightly different ballot. But in terms of the issue at hand on proposal 3, their vote matches. It was a legitimate process that was undertaken to give them this ballot. Mr. Brader, do you have anything to add to that?
Well, so that's the procedure if someone sent the wrong precinct or wrong ballot style. So if you accidentally sent the wrong ballot style, they return that. Ideally, you're going to catch that earlier, tell them, and then communicate with that voter and send them a corrected ballot. But if that doesn't happen until Election Day, or if they only send back the original ballot, then the proper procedure would be to duplicate that ballot onto the correct precinct or county ward for the races for which the person's eligible. I don't know exactly why this person, and I assume the recount team did not know exactly why this person had the wrong original ballot. But in terms of duplicating it onto the correct ballot style for that voter, that's the proper procedure.
Okay.
I would note that it is important, I think, Mr. Brader, is it not, to make sure that it does get duplicated so that it is counted in the right AVCB board? Otherwise, it creates an imbalance.
Exactly. And, yeah, that's correct. And also that person would be voting potentially in some local races that they may not be eligible in.
Microphone.
Chairman Daunt, I would indicate that in order to duplicate a ballot, you have to have statutory authority to do so. The only statutory authority that is granted is under 168-798A, and it indicates that a duplicated ballot can be used if a ballot is damaged or defective so that it cannot properly be counted. A true duplicate copy shall be made and substituted for the damaged or defective ballot. This process is created out of thin air. It is not a process by which Michigan legislature has authorized this action. It is an ultra-virus act. It is something that is once again done in the holy pursuit of to stop a voter from being disenfranchised. But it's not authorized by law. It is a made-up process that is used, which is not authorized by a statute. When I was attempting to point out that HAVA 301A6 defines what a mark is supposed to be, this is a federal law, and this election contained other parts of this election which are federal law, and Michigan complies, and we took the HAVA money and we said that we would comply with the requirements of HAVA. And HAVA says that you have to have a non-discriminatory definition of what a mark is, and the instructions are part of the definition. You can look at HAVA 301A6, and what I will just indicate to you is now we have a process where we are duplicating. This is an example. There were many more than this. But the problem is that you can't take a voter where we don't even know why, but when they weren't in the poll book, the ballot didn't match from the poll book. So I don't know why that happened. There was no investigation. What did we do? We took the ballot and we duplicated it onto an absentee voting counting board 6, and we said, okay, we don't want to disenfranchise the voter. But you know what really is disturbing? We don't even know if it was a real voter. We do not know because no investigation was made. And what you have a problem is you have a ballot that the security feature is a signature which we have no standard for despite the Genteski case. We have a signature which was the only means that we can identify this. So you can't tell me we've disenfranchised a voter any more than I can say that you've deluded somebody else who's lawfully a voter under equal protection. The problem is we do not know, but we do know that this process is a made-up process that's not authorized by statute. Thank you.
You may not. Mr. Brewer, you guys were moving the computer like you were talking about something. Was I just assuming that? Okay.
Thank you, Mr. Chairman. I agree with the explanation you provide as well as Mr. Brader. I'll just point out that under the statute that was just cited, this ballot was defective for purposes of AV Board 4. That's why it had to be duplicated. So this is a process that's entirely authorized by statute. And again, we look at the Constitution. We are to protect the right to vote, and that right is to be liberally construed. And the local board did the right thing here, and I urge you to reject this challenge. Thank you.
Thank you. The attorney has done a good enough job. No, I'm all set. Thank you. Thank you. I will entertain a motion.
Mr. Chair, I move the Board of State Canvassers reject the challenge number 119.
I'll second it.
We have motion and support, discussion. Seeing none, all those in favor of the motion signify by saying aye.
Aye.
Aye. Any opposed? Motion carries 4-0.
Can I ask one question?
You may.
Okay, it's just a follow-up, but I can't get the answer up here. Something tells me that city of Detroit, that precinct 6 and precinct 4, is it possible that voter was on the line of a redistricting? Because that would change, that would certainly touch your poll book.
That's a good question. Somebody should investigate that.
It's not me.
Good ideas.
That concludes agenda item number 5. We are now on agenda item number 6, which would be the certification of the partial recount of proposal 2022-3. Mr. Brader, are we clear to proceed with that, given the work that we have done on agenda item number 5?
Yeah, as we noted, that number will be adjusted in Van Buren County, but otherwise, yes.
Okay. I would entertain a motion on agenda item number 6.
Let me do that one for you.
Mr. Chair, unless,
No, go
you
for
want
it.
me to go? All right. Mr. Chair, based on the examination of the partial recount of the votes cast on November 8th, 2022, general election regarding proposal 2022-3, I move that the board certify that the attached is a true statement of the votes given in the election, and I further move that the Board of State Canvassers certify that state proposal 2022-3 passed.
I'll second.
Motion and support. Any discussion? Seeing none, all those in favor of the motion signify by saying aye.
Aye.
Any opposed? Motion carries 4-0. All right. I will say, despite some significant frustration and eye rubbing through this process, I appreciate the input from people on both sides. It got heated at times, but folks were pretty overall respectful of the process. Thank you again to the staff who did all of the work going through these, putting it together, giving us our packet and our recommendations, and helping us through this process, and to my fellow board members for another long day. We do have item 7 and then 8 of public comment. 7 is other business as presented to the board. Are there items related to that we seek to address?
Mr. Chair, if I may, this process is not easy, and it is not easy to sit in these chairs at times. But we are all human, and we all make mistakes. Whether you are sitting there and voting at home, or you are voting in person. And as much as we can put those instructions, we saw, and I know that those of you who witnessed and went through these recounts, not everyone votes in every race. Not everyone follows the rules and the directions. And that's why we have process here, and that's why we went through this here. And I have a feeling that we'll be back here again, as we always are for every election. But it's just, I've been quiet today. One, honestly, I missed the last meeting because I had my actual job to do. But we want to have people in the process, but I feel those who have been watching this, who may not have been in this process before, having questioned of, you know, I made a mistake on my ballot, now they're going to question whether or not they're going to count my vote. And I know that some of you might not feel that way, but if you hadn't seen the process before, you could. And there are a lot of questions, there are a lot of things that have to be addressed. And unfortunately, this board may not be where that has to happen. And I can understand the frustration level on that. But I just wanted to kind of make some comments because I was a little quiet today, Mr. Chair. But On that, I would like to know or note any litigation from the Attorney General's office, our update of who's suing us and things of that matter.
I think the only cases of consequence that we still sort of have pending are the appeal in the O'Halloran and DeVisser cases on the Challenger rules. And then we also have the Ickes or Ikes complaint in the federal court still that's pending.
Other questions or comments before we move to public comment? Okay.
Yeah, Mr. Chair, I would like to have, I would like to have a brief closed session, but I think we should have public comment first.
Okay. So, public comment. We've got just a little more than a handful of these. I'm just taking them in order as they came up and are in the pile here.
Chair Daunt, just a
Yes.
reminder that we have one remote.
Yes. Thank you. And we have a remote comment. I will, again, you got 1 minute. I will be pretty strict about that. And we'll kick it off with Mr. Gallant, who is remote. Mr. Gallant, let us know when you can hear me. I will just keep talking.
Can you hear me?
Yes, sir. All right.
This is James, James, Gallant, Gallant, with the Marquette County Suicide Prevention Coalition. And Mr. Daunt is pretty disingenuous. You're not going to be following Robert's Rules of Order because Mr. Brady, the Director of Legal Services for the Department of State, has determined that under the Constitution you have to follow Robert's Rules of Order. And now, you did every single time you had a discussion first, you turned around and said, well, okay, now that the discussion is exhausted, you will entertain a motion. And then you say, oh, now any other discussion. That's completely disingenuous. You should be getting an Attorney General, the real Dana Nessel Attorney General opinion. And I was at your recount for Marquette, and your employee from the State Board of Canvassers you sent there interrupted me and denied me my public comment during my county canvassing board meeting. And during the other county canvassing board meeting, she said that she would entertain a motion. So your employee took over the meeting, said she was making decisions on behalf of the county canvassing boards, completely inappropriate, and the certifications took place with 3 members. Even the State Board of Canvassers, you had 3 members when you certified. You had a Republican. It's Article 2, Section 7 says there shall be no...
Thank you, Mr. Gallant. That is your 1 minute. Up next, and what I'll do is give the person coming up,
Have a nice day.
and then, thank you, Merry Christmas, the person on deck so that you are ready. So, first person, Kristen Dornbos, and after Kristen is Tricia Fessler. Reminder to state and spell your name, and then we will start your 1 minute for public comment. Go ahead when you're ready.
Hi, my name is Kristen Dornbos, Kristindornbos. I was a counter in the recount, and I just want to state that we are given 2 chances, and we did not meet the number, so it's unfortunate we are unable to recount. I'm really disappointed in that. I wanted to get the scans of the ballots, and unfortunately, our Ottawa County clerk said that time is more important than accuracy, so the scans were turned off. I'm going to have to go raise money to get scans of all those ballots because I would like to do my own audit. So I hope that in the future, maybe we have those scans turned on. And Ms. Gurwitz, I just want to say this might be frivolous to you, and it might be a fishing expedition to some of you, but I just want to remind people that in Germany, the Nazis got into control by legally taking over, and then they changed the elections. So while you roll your eyes, it's really important to me. Thank you.
Thank you. Tricia Fessler and Shirley Schaefer on deck. Tricia's gone. Shirley Schaefer? No, Shirley's gone. Scott.
very much for the time. I got my little thing going here. I just wanted to say.
Mike.
Scott Augney, S-C-O-T-T. Augney is A-U-G-H, N as in Nancy, E-Y. And I just wanted to make a couple points. Number one, you mentioned investigations. I've reached out to Michigan State Police on multiple occasions in Jackson. They don't want to touch us. Most cops don't want to touch us because the Attorney General's office under Dana Nessel has had an intimidation campaign going. And it's not targeted at Darleaf or any of the other 9. It is targeted at every other law enforcement officer and prosecutor so they won't cooperate. With regards to this whole election recount process, all sterility was used at the canvassing sites, but the sterility of this board was absolutely non-existent. You have a dirty approach to the law.
Thank you. Ken Byer. And after Ken, would be John. No, I asked you to say this earlier, and okay, thank you. So Trish Oliver would be. You want to speak? So you're on deck. Okay, go ahead, Ken.
Ken Byer, K-E-N-B-E-Y-E-R. Mayor, you said that this was a colossal waste of time and I was an election denier. I took off 3 weeks of vacation to investigate before I just said I'm not voting again. I was at TCF Sunday, Monday, and Tuesday as a poll challenger, and I was in Midland, Lansing, Kalamazoo for 2 days, Allegan County, and then Van Buren County. I witnessed walk-in ballots that were folded. I saw folded ballots that were actually, where people walked in to vote. Then I saw ballots that were cast by mail that weren't voted on. Then I was in Midland, where we couldn't recount 5 of the 9 precincts. This right here is a ballot canister. It's actually, I grabbed it from my plumbing business. This is what we store our plumbing parts in. This is what they tried to pass off as a ballot canister. Of course, it wasn't accepted. I wish I had this in my business. When the IRS comes to audit me, I'm sorry, I can't see your receipts. Here's my receipts, but I broke the ballot canister. It's not appropriate. It can't be counted. I don't know how this is acceptable.
Thank you. Trish Oliver.
Hello, I'm Trish Oliver. I apologize in advance. I'm going to speak fast because I have a lot to say.
Spell your name.
Trisholiver. I served as an EIF poll challenger for the recount for Oakland, Wayne, and Genesee. Promote the Vote attorneys Mark Brewer and Chris Treblecock today stated that poll challengers threatened election officials with criminal prosecution. On December 7th, I did state to State Board of Election official Lori Bourbonnais when she refused to accept my challenge in Oakland, Troy, regarding seeing both sides of the ballot, that interferences with a fair recount is a felony per 168.873. I would expect that Board of Election officials are professional enough to hear this as a statement of fact, not as a threat. And if they are duly doing their duties without interfering with the law, it's not a threat whatsoever. Furthermore, Treblecock spent most of his time during the Oakland recount in Troy sitting amongst Board of Election officials. This level of fraternization between Promote the Vote attorneys and challengers is concerning, as it infers the recount wasn't fair or impartial. In addition, Mark Brewer at TCF in Detroit physically blocked me, and when asked, he didn't remove himself. I found this threatening. Mark Brewer has attempted to undermine people interested in fair and transparent elections as election deniers. I would ask him to be more, I ask him to be more respectful of the electorate. As poll challengers, particularly at TCF, which was a hostile environment, the cards were stacked against us. I was gaslighted and ganged up on by Promote the Vote poll challengers, as Braden has previously stated. There is no provision in the law that authorizes an interested elector.
Another minute in, Trish. I've been
Okay, so to finalize, I do find myself wishing during these Board of Canvassers meetings that we had GOP representation on the board. And I wonder how the so-called GOP canvassers here today feel that they are doing more than concurring with the Democrats' ones. I have heard arrogance, condescension, and dismissiveness, and I would like the entire board to take the electorate more seriously as we are spending our valuable time overseeing this important process. Thank you.
Thank you, Trish. Donna Mullins, and after Donna, the last we have is Jacqueline Stewart. You've exhausted. Also, you guys had your chance during the comment during the various challenges. These are the two that we're going to finish with. I think we are all set. And Donna, go ahead.
I'm Donna Mullins, M-U-L-L-I-N-S. I'm the president of the Lansing Area League of Women Voters. But today I'm representing the state because they just wanted to say how much we appreciate the careful and professional work the election workers conducted in all of the counting regions before and after the election, and we're confident the final results are correct. The league promotes civic engagement, and we certainly have seen it today and the entire year, and we couldn't be prouder to be Americans. Thank you.
Thank you, Donna. And last, Jacqueline Stewart. Don't forget to spell your name.
Just give me a second. My phone is almost out of juice, but that's where it is. All right. My name is Jacqueline Stewart, Jacqueline-Stewart.
Okay.
Also a member of the League of Women Voters, Lansing area. Speaking partly as a member of the League of Women Voters, but also as a person who went out and observed what happened at county canvassers. So I'd like to start by thanking the Board of Canvassers here, their assistants, and also the faceless and nameless people behind there who were at the county canvass level and worked the precincts. I'd like to thank you especially for persevering in the face of mostly unjust criticism. I particularly want to reference a short speech in the last meeting by Mr. Hauskamp about the unlikeliness of fraud in the system. He mentioned how at each stage people who had signed up and trained to do so laid their hands and eyes on ballots, tabulations, poll books, and these were always handled with extreme care. That has been true of my own observations at the county level. There was no place for fraud unless you believed in a really massive conspiracy of all these people. In fact, out of millions of votes cast, today challengers identified 119 cases they wanted you to adjudicate. These challenges have been rejected, often because the issues are not relevant to the process today. That is not to say that other actions couldn't happen. Or because the challenge would not allow the voter's intent to stand. As with my previous experience observing, I'm impressed with the care you take about the voter's intent.
I
can wrap it up.
Wrapping up?
Yeah.
Thank you.
Despite this, some people still believe in conspiracies and without evidence will accuse good people of wrongdoing. I have no doubt that the challengers today passionately believe their theories. I don't think they're untruthful or they're bad people, but I also have no doubt that their theories are nurtured by other sources that don't necessarily believe in the theories that they spread. Conspiracy theories are the arrows, believers are the archers, and civil society is the target. So, there are many more people who know that you all did the right thing than there are people who believe you did not. Bravo to those who have remained civil and served society under this pressure. Thank you.
Jacqueline? All right, that concludes public comment. Oh, Mr. Hauskamp?
Is it okay if I ask Ken a question?
Sure.
Ken, first of all, just thanks for taking 3 weeks of vacation time to do the voting. The box, I guess I'm unclear. I didn't catch all of that. Is that an actual?
This is an actual Well, it's what I'm using for plumbing, but it was what I saw when we went into Van Buren County for 2 precincts.
So it's an example of what was in Van Buren County.
Yeah, and I wouldn't be concerned. I mean, people make mistakes, and they need to save money and get this really cheap at Menards, but this isn't what they should be storing the ballots in. You can remove these pins, and I didn't disagree with the fact that this is, something that could be tampered with.
What was
However, what I'm concerned about is they didn't store all their ballots in them, just the ones that they wanted us to recount. And the 6% of the ballots that were out there, are you rolling your eyes, sir?
No, I'm.
Oh, okay. But the ballots that, that we wanted to recount, we couldn't recount because they were put in these kind of containers. The ballots were broken, the seals were broken on some of them. So we couldn't count the ones we want to look at. So this is a perfect place to hide a smoking gun, if there was one. If not, open them up and let us count them. But with that, the way that the law is designed, we can't do that. So that's really concerning to me. Why would they put the only ballots that they wanted us to recount in there?
What was the county?
Van Buren. Van Buren, Midland. Didn't have any problems in Lansing, but Kalamazoo, we had one.
You experienced that in Van Buren?
Yes. 2 separate precincts. So it'd been 2 different clerks.
Okay.
So 60 precincts overall were not recountable.
Mr. Chair?
Yes, go
May I
ahead.
ask a question of Director Brader that's relevant to this conversation?
You may.
Thank you. Director Brader, how many different types of election precinct canisters are certified to be used in the state of Michigan?
So this list is publicly available on the Bureau of Elections website. It's approximately 20 types of containers that are approved. They're not certified, but they're approved for use. And that list is on our website.
And I say that because I live in Brandon Township.
Yeah.
It's very public where I live. And we have what I like to call a glorified sewing box. It's a very tall box. It's very narrow. For those of you who do crafting, you know what I'm talking about. It's actually cloth. But there's a locking mechanism that can be locked. That's where your seal goes into. The township next to mine is Oxford. We recounted a house race there for the Republican primary, I believe it was in 2014. And in the transportation of bringing those ballots from Oxford, now Oxford has, instead of it being a tall rectangle, has a very wide rectangle, very horizontal, and in the transport, one of those zippers broke open. That was a precinct we could not recount.
Yeah.
And there were issues, and there were issues that were discovered in the recount. But I say this because I have those too. And I think I questioned with my member Hauskamp that that's a little strange. But I also wanted to make sure that everyone knows that that information is public, that those canisters are. And I've seen a recount from Kego Harbor. They had silver boxes. They were just tiny little boxes.
Yeah.
So it all depends, and that is a little alarming that you said that is from Van Buren, that the similar would be in Van Buren. But I just wanted to make sure that that information was out in the public.
To be honest with you and just forthright, I cheated my way through high school. I did fairly well doing that in college. I've changed my ways, but I would love to have this as my homework box, or just like I said, to show to the IRS. I mean, with those kind of rules attached to that, you can't look inside this if something's wrong with it. There's something terribly wrong with that law. And I met great people. I told Mr. Brader that. I said, I really met some great people working for the Secretary of State in all the places I went to, the 5 places I went to. It was amazing people. But it looks like he has some awful laws that if you were back when I was in high school and college, I would be using that like crazy. That would be an amazing place for me to hide something I did wrong or, something I didn't do right would be in here. Anything could be in there. And the fact that we can't look in that, it makes me suspect of if this is a system I want to participate in.
Unfortunately, that change can't come from this board.
I know, but can you make a recommendation to somebody? Just let us know that you care,
Let me turn that one around for you.
please.
You've done some thinking about this, and you got a long drive home if you're from Van Buren.
Yes.
Do us a favor. Take the time over the holidays. You know what a synopsis sheet is, right?
Yep.
Make up a synopsis sheet with a couple of how do we fix it?
Okay.
I can't promise anything, but I can promise you that we'd read it.
Okay.
And at least be able to share it with people.
That's fair. I will definitely do that. Thank you for that recommendation.
Yeah, please do that, though.
I will.
I'll look for it.
Okay, I'll follow through with that. Can I get your card?
Yeah.
before we leave?
What we'll do is we'll have you send it right through to Adam and Jonathan
Okay,
at elections, and then they can serve it to us.
sounds great.
You're welcome to a card, too, but I don't have one.
Appreciate it.
All right.
Thanks.
Are we set? All right. No, we're,
Appreciate your patience.
yes.
Thank you, sir. I want to thank you guys for going through the issues and talking about things, and I want to dispel something that is out there, and that is that this was for anything other than to try and improve the system. Not only were ballot boxes discovered and other things, the idea wasn't to change the outcome. The idea was so that we as citizens could look at the election system, because we weren't getting audits, we weren't getting other things. And there are a lot of questions that were answered, and there are a lot of questions that arose. In response to what you asked, Mr. Byer, we are going to make a list of things that we would like to see enforced, improved, and changed. We'd like to see the rules of the law followed. But I would just also echo what Mr. Byer said, is this was a very educational, informative process that needed to happen. It has been a long time since the state of Michigan has looked at this, and I'm sure that the Secretary of State has learned things that they're going to do from. So some of the hostility that has happened is maybe from a misunderstanding. Election Integrity Force isn't a proponent of any of these proposals or an opponent of them. They wanted to make sure the election is conducted in the best manner possible. And I just wanted to say thank you for your patience today. Chairman Daunt, you and I have had some words during this process, but I appreciate your patience with me today and the way you conducted the hearing. Thank you.
Thank you. Merry Christmas.
Chairman Don, may I ask a question, Director Brader?
Yes.
Director Brader, how many audits were performed after the 2020 election?
More than, well, there were at least 250 conducted. That doesn't count the risk limiting ballot audit that was done, but there were at least 250 precinct and absent voter county board audits. We'll also be doing a similar number now. We would have already started those, but they have to take place after the recount, so they'll be happening in January. I would just note that most of those audits, they're done under the supervision of the Secretary of State, but it's actually county clerks, our 83 county clerks, that do most of those audits. So it's actually done by officials of both parties throughout the state.
Thank you, Mr. Chairman, for allowing me to ask that question, and I will follow it with, I'll go back to 2016, when we recounted the entire state, and there are questions of why we did that. And I am the only board member here, and you can shake your head at me all you want. I'm okay with it. I'm used to it. But this is why I say this.
Mr. Hartman?
Can I please finish? I think I've not said anything to anybody. I try not to, because I know what it's like to be on the other side of those words. In 2016, we had not a full recount, but there were recounts, and they happened in Wayne. I live in Oakland, where I observed Oakland. I went to Wayne County. Those recounts happened. And there were things that were found during that recount that I'm not saying they're completely addressed, but those issues were starting to be addressed because they were shown. I appreciate when people come and say, I have questions. Are we at a point where elections are perfect? No, we are human. Okay? So when problems are brought here or brought to your county or city clerk or brought to your county clerk or your county board of canvassers, I know it's hard, but we are listening. And if we're trying to tell you that sometimes we're not the avenue for that fix to happen. But I will say in Wayne County, the day after that was halted, yes, it was halted. I wish we would have continued, because I believe that some of the things that you are bringing up to us would have been found throughout the state. And I remember walking into the gallery of the building that we are next to, someone throwing a microphone in my face and saying, "Tell us about the voter fraud." And what I told them was, there are errors, there are training issues, and there are things that we need to address. And that is the important thing. So when people tell me, no, we stopped it, it didn't change the fact that we found issues. And like I said right before we started, we are probably going to continue to find issues. Okay? Please don't, I've sat here the longest than the other members of this board. And I've been to recounts, and I honestly, I wish I could have been at these. But I do have a job, and I was out of state, and I couldn't attend them. I know, I was out of state. Can't be in two places at once. But I normally would go, so that I would know firsthand what was going on at those recounts. That's all I want to add, Mr. Chair. Thank you.
Thank you.
Mr. Chair, I move that the Board of State Canvassers go into closed session to discuss litigation strategy in Ickes versus Whitmer et al., case number 122-CV-817.
Mr. Chair, I support the motion.
We have
We have to do a recall vote. We have to do a recall vote. Not a recall vote. We have to do a roll call vote.
Oh, thank you.
Sorry, I'm trying my recount on my head.
Please do not mention recalls right now. We have a motion and support. Any discussion on that motion? All those in, no, roll call vote. Would somebody like to do the roll, or is it okay if I, go ahead, Adam?
Chair Daunt,
Yes.
Vice Chair Gerwitz,
Yes.
Member Hauskamp,
Yes.
Member Bradshaw.
Yes.
Mr. Chair, you have 4 yeas.
Okay, so we will now be going into closed session. We will be leaving, and it will be just us with legal counsel. We will then need to come back into open session and adjourn the meeting. Is that correct?
Yes.
After we close the closed session.
Yes, that's correct.
Okay, well, let's go. First closed session?
Yes, that's okay. Yeah, because you have to come back in an open session to adjourn.
All right.
Yeah, I will.
So we we closed session, and, oh, okay, geez.
Oh, we're ready to go.
All right, so we closed session, and now back here, it is my understanding that we have exhausted and addressed all of our agenda items. Is there any other business or items that members would like to discuss?
Just one thank you to the guys in the back in the uniform. Hey, you know what? You guys have kept us safe now. What's that, four meetings? Is it? You get to take the thanks for everybody then.
I'd like to thank the Attorney General's office for also providing us, and as well as staff and everyone, have a wonderful holiday season.
Indeed.
Also, I don't know if any of them are in the room, but also the Department of State Office of Investigative Services was also helping with keeping us safe, so.
I think we don't need a motion. I can just adjourn this thing, right?
Just pull a Norm, just
Yep, adjourned.
Norm used to tell me all the time.
4:24.